Make sure I have the case page up. What's his name? Henry, right? Henry Cortland. Hey, Ashley. Just started streaming, so making sure I have everything open. You guys hear me okay? Yeah, this is the Florida. I don't know what exactly. Like they have their IP and wireless ID on there. I don't know if that's a good idea, but it is what it is. Hey, factual. So I don't know what this is even about. So I'm just gonna kind of wing it here. See what happens. So yeah, this is YNW Bortlen, aka Cortland Henry or Henry Cortland. Cortland Henry. So I know this got some attention. I think this is going to have the plea offer in this case, which I know was 16 years with credit for time served. I want to know how YB can tour and sing about everything YSL was indicted on, make it make sense. I don't know, man. As long as he stays out of Fulton County, actually, I think he spends a lot of time there. I don't know. I don't know why YSL was indicted on a lot of the stuff they were indicted on. We could do a whole show about that, though. I mean, they kind of took some people who were guilty of things and like sprinkled them in to dirty up the rest of them. It was just a mess. I'm worried about Pusha T though. If Pusha T was from Fulton County, his whole career would be different. Every Pusha T song's a Rico. Michael Sprinkle. Let's see. Saw that with Cat, where the judge decided he wasn't in custody. No, that was today. Um, I'm starting with yesterday's. I think. I'm pretty sure. But again, I haven't seen it yet, so I could be wrong. But okay, I'm just gonna go ahead and get started on this. See what it is. In any second now. Come on. Come on. I just know if I press fast forward, I'm gonna go too far. Come on. I know this is great watching. Yeah, the audio is terrible. I did like a live coverage of one, and I just couldn't hear anything, so I just kind of pretended.
On the bottom of my page 2. The case on the top of page 2 is 19-1871 CF10A. The case on the bottom of page 2 is 23-10643 CF10A. I've got Mr. Griffiths and Ms. Collins present for the state, Mr. Haddad, Mr.
How's that for you guys so far? I know it's not like high quality, but volume wise. Oh yeah, like. Thanks, Aaron. I should say like some kind of legal theme thing, like convict the like button. 7 out of 10. Yeah, I mean the quality. I can't do anything about the quality. You know who does a really good job with the sound is Cuff Voice. I'd like sometimes I would listen to his like during YSL. I'd listen to his coverage just so I could. I mean, it was good, but just so I could hear some stuff that I couldn't hear on the regular coverage or other people's streams. He's really good at making sound better. But okay, I guess we'll just go ahead with this. Convict the like button. Throw the like button into Rice Street and don't let it out on bond. Indict the like button for a RICO. 65 counts minimum.
Mentor present for Mr. Henry, Ms. Messment. I know you got to run CJ Siegel. I set today and tomorrow for all pending motions. Let me put a couple things on the record, and then I'm happy to listen to any evidence, witnesses, or testimony each side wants to present. Just save your arguments to the end, and then when we get done with the evidentiary portion today, if we're going to continue on to tomorrow, that's fine. But it's my understanding that there was a global offer extended to Mr. Henry, so I'm going to put that on the record and have a quick conversation with him about it, but I'll do that after we...
Come on, you're not wearing a tie? Can you see my mouse thing? Why can't you see my mouse thing? You're supposed to be able to. Oh, there you can. You can. Okay. Come on.
Get done with the evidence today and get the witnesses out of here. So, in preparation for the hearings today and tomorrow, I read the following. Number one, the defendant's motion to suppress statements of Cortland Henry that was electronically filed December 5th, 2023. I read the state's unopposed motion for relief from the trial order dated July 8th, 2024. That was electronically filed August 25th, 2025. I read state's memorandum of law in opposition to defendant's motion to suppress statements of Cortland Henry, as well as the attachments contained therein, which are transcripts. I couldn't find this one filed on CMS, but I assume Mr. Haddad got a copy of it. I couldn't find it.
The audio copy evidence you should already have.
Right. I did listen to, on the thumb drive that was provided to me, 2 audio recordings. I guess I'll have to wait to hear from the witnesses to tell me who's on the audio recordings. But I did listen to them. One is labeled Exhibit A, one is labeled Exhibit C. They're both dated October 26, 2018. Jesus. One of them was at 6:50 a.m. in the morning. The next one was at 7:46 in the morning. I don't think the grand total of both audio...
That was my first semester of law school. And that's how far back we're going.
Takes up an hour. In fact, I'm sure it doesn't. But I did listen to all of that. So I did also read all the authority that is cited therein, in all the defense pleadings and in all the state's pleadings. Again, to repeat myself, I will let each side present whatever evidence, witnesses, or testimony they would like to present. With regards to any of these pending motions, I'll just ask you to save your arguments until we're done with all of the evidence. And
I do have the docket open, so we can look at any motions if we don't understand. And by we, I mean me. You guys probably know more about this than I do.
And then I'll give you a ruling as to all of them. I know we're set for tomorrow at 9 o'clock, and I know we're likewise set for trial. In both cases, 9 o'clock next Wednesday, which is September the 10th. So that being said, state whenever you are ready, you may proceed.
The state would call, one motion to suppress, state would call defendant George Cox, Officer George Cox.
That's having that printer right here. Hang a second.
You swear to tell the truth, whole truth, nothing but the truth. Please be seated. And so once you are seated, if I need you to scoot that chair forward as far as it'll go, you can adjust that microphone so it's pointing directly at your mouth. Can you please state your full name and spell your full name?
Jordan Cox, Jordan Cox.
Mr. Griffiths, you may inquire.
The court is willing to question from the table to the records to find the next.
Not a problem.
Officer Cox, who do you work for now?
Boca Raton Police Department.
And how long have you worked for them?
Approximately 4 years.
I want to take you back to October 26th of 2018. Who were you working for back then?
Miramar Police Department.
And what were your duties back on October 26th of 2018?
Rural Patrol.
That evening, that early morning rather, where were you working?
Where was I working?
Yeah.
What is she reading?
The city of Miramar.
Any sites in particular, any locations in particular?
No, I was on FTO, so I was kind of roaming around the entire city.
Did you have an occasion to be called over to the Miramar General Hospital?
I did.
And what brought you to that location?
The detail officer put over the radio that there was 2 victims that were shot at the hospital.
Brought paper up with him. Now he's
When you arrived on the scene, what did you observe?
I observed the SUV parked underneath the emergency bay with bullet holes all over it, and there's a black male subject sitting on a bench.
Did you know who that black male subject was?
At the time, no.
Did you later identify or learn who he was?
Yes.
Who was that individual?
Cortland Henry.
He's reading.
See Mr. Henry in the courtroom today?
I do.
You could identify him by some clothing that he's wearing?
That day?
No.
Or just now? Just now, yeah, based off him and his tattoos.
Okay, so you see him in the courtroom today?
I do.
Where do you think you could identify him?
He's wearing a red jumpsuit.
How can he tell it's a jumpsuit? You can't see below his
Okay,
waist.
record shall so reflect. You may proceed.
How does he know it's a jumpsuit? How does he know it's a jumpsuit? Is it possible that he's just, identifying the guy who's sitting at the defense table? Because he can't possibly tell it's a jumpsuit from where he's sitting. So, he's full of shit.
At any point in time, did you have a conversation with Mr. Henry?
I did.
Kerner says, I always hate this ID process. They should sit the defendant in the gallery and make them ID them. That was actually a case that we read in ethics in law school. There was a lawyer who did that. I think they copied it in Better Call Saul. Well, they didn't copy it. They were inspired by it, I guess. I think it was a Coast Guard case, maybe. It was something in the ocean, and the Coast Guard officer was called to identify the defendant. And the defense lawyer had actually put his client in the gallery and had a random person sit next to him. And the Coast Guard guy identified the guy sitting at the table because, of course, he did. And then the defense lawyer was like, "Hey, gotcha." But then the court was mad for defrauding the court, and they switched the people, and they let the Coast Guard witness identify the defendant once he already knew who he was, and after he had already gotten the ID wrong. And CIS too. Yeah, it was. Spence Wood. Yeah. Yep.
And what did that conversation consist of?
Upon arrival, I pretty much asked him what had happened, what was going on. Based off, he looked like he was in distress sitting on the bench. So just trying to figure out what was going on.
What was going on? What was going on around you when you first started talking to him?
We had medical personnel coming out of the hospital, trying to extract the victims from the vehicle, get them inside, and apply aid to them.
Were there any other officers present?
Yes.
Do you know how many were present?
He's reading.
I don't recall.
Do you recall where they
Or
were?
not. I don't know.
Where they were standing?
The officers?
Yes.
I had my FTO next to me, Officer Luna, and Jessica Amengor. She was standing outside the emergency room.
So it was just you and Officer Detective Luna who were talking to Mr. Henry?
Yes.
How were you dressed? How were the both of you dressed?
Road patrol uniform, Miramar Police insignia.
If you could just briefly, what was your conversation with Mr. Henry?
He's clearly reading. He's looking through the papers. It's not trial, so it's probably different.
I can refer to my report.
Yeah.
That's fine.
You just did.
Yes.
What are you talking about?
Oh, yeah.
Excellent witness, by the way.
Yeah, so based off the what I observed with the vehicle and the victims, pretty much asked them what had happened, what was going on, where did this occur, how did this occur. Just
He needed to check his script to remember, hey, what's going on?
to get basic general information to provide to the detectives that were going to come on scene.
And did he provide you that information?
Yes.
Did he tell you where approximately this incident, where the two individuals in the vehicle have been killed? Occurred?
Yes.
What did you do with that information?
I provided it to the detectives that are right on scene.
Approximately how long were you speaking with Mr. Henry?
I don't recall.
Long period of time, short period of time?
Approximately about an hour.
And the entire conversation, where did that take place?
In the outside emergency bay, and then he was either admitted. He was either admitted to a room, or they took him into a room, and we spoke to him in there as well.
Father into the hospital. Question.
And
Great.
at what point did you, at any point in time, did you leave Mr. Henry?
I did.
When did you leave?
Okay, we need to revisit that question. That was funny.
And at what point did you, at any point in time, did you leave Mr. Henry?
I did.
When did you leave?
When I had finished talking to him.
Were there any other officers present when you left?
I would say another officer took my role and stayed with him when I left the room. Yes.
And do you know when the detectives arrived?
I don't.
Is he trying to like side eye his report like we can't see? What was that?
At any point in time when you were with Mr. Henry, did you ever advise him that he was in custody or under arrest?
No, I didn't.
That doesn't matter at all.
Okay, cross-examination.
Good morning.
Good morning.
You proceeded to the Miramar Hospital because of the dispatch.
Yes, sir.
He was taking so long to walk to the podium that he had to start his question beforehand, so it wouldn't be awkward.
And was dispatched to all units. How many police sergeants ended up being there?
I don't recall. Good amount?
Fair amount, more than a few.
Yes.
Someone said it was like a whole Miramar Police Department spot. That's what the duty. Would that be fair? Anybody on duty at that night?
I wouldn't say everybody, because there's a whole city to patrol. A good amount of units were there.
If you could give a guess, was it more than 10 policemen there?
I don't recall.
How many do you recall?
I'm sorry?
How many do you recall?
Approximate?
Yeah.
Did he just say, I don't recall, and then the question was how many? That was weird.
A good amount of units were there.
If you could give a guess, was it more than 10 policemen there?
I don't recall.
How many do you recall?
I'm sorry?
How many do you recall?
Approximate?
Yeah,
When I arrived on scene, it was just about 3 or 4 units on scene.
3 or 4. By the time you left, how many were there?
Probably 10 to 12.
10 to 12. Okay. Now, let me ask you this. When you arrived, you saw the chief's office. It had a couple of people in it. Did you see this?
Correct.
Okay. And Mr. Henry was out in the car?
Correct.
You know, the police lady, excuse me, the person in charge of the emergency room had him sit on the bench awaiting the arrival of the police.
I don't recall.
Right. Nobody had extracted the body here, correct?
Not that I saw, no.
Was there an investigation into the cause of death ongoing at this time?
I don't recall.
Did you investigate the cause of death?
I did not.
You asked Mr. Henry what happened, correct?
Correct.
And he told you what?
That he and his buddies got shot at in Fort Lauderdale. They were leaving a party.
But didn't you say that he advised an unknown vehicle drove by and fired multiple shots that he was driving? Is that what you report?
Correct, on the highway.
Yeah. Okay. And you said he told you where it was, and your report of the units responded to the area of I-75 Miramar Parkway, looking for evidence of the shooting. Units were unable to find any casings or shattered glass, correct?
Correct.
That was What time? Did you direct him to know the area you were shooting?
I did not.
You know who did?
I do not.
He told you, when he told you the area you're shooting, you noted it here, correct?
When you say that, I'm sorry, repeat?
Your report notes the area of the shooting. Does that come from something you heard from Mr. Henry? Does that come from a compilation of the other reports?
It's what Cortland Henry advised to me.
Okay. Did you pass that on to the detective?
I love the way police talk. They have like this unique vocabulary. The way he advised to me. It's just like a specific like pattern of speech, vocabulary.
Was there anybody else?
I did.
You dispatched it over your
No,
radio?
no.
Well,
I spoke to the detectives.
Okay. Did you tell anybody else this is where the scene was?
Not that I recall.
Did you go to the scene?
I did.
You did?
I did, yes.
Did you go look for evidence of the shooting
I did.
before the detectives arrived?
After they arrived.
Okay. Did you find anything?
I did not.
Did you report back to the detectives you didn't see anything?
Correct.
Who was with you when you were doing that?
Multiple Miramar police officers.
Okay. The detectives hired you over at the hospital?
Correct.
They were not looking, correct?
Not that I recall.
Thank you very much.
Based on that, any redirect?
No, no.
All right, state is the witness excused. All right, sir, you may step down. Thank you very much. While he's doing that, state, you may call your next witness.
Same call. Steven Toyota.
What is this dull word?
Huh?
Toyota's coming in, you want to come?
I have?
So loud.
Sir, if I could have you come all the way up to the witness stand, please. Once you reach it, but before you have a seat, you can just stop and look at me, please. Raise your right hand. You swear to tell the truth, whole truth, nothing but the truth. I do. Please be seated. Sir, once you're seated, if I could just scoot that chair forward as far as it'll go. You can adjust that microphone so it's pointed directly at your mouth. Can you please state your full name and spell your full name?
Stephen Toyota, Stephen Toyota.
State you may inquire.
Good morning. Capital Dynamics. It's a global investment firm.
And back in Oxford, when did you retire from the Miramar Police Department?
February of 2021.
And were you working with the Miramar Police Department back in October of 2018?
I was.
In what capacity?
Homicide detective.
And on that night, did you receive a call to respond to the Memorial Miramar Hospital?
It was the morning of the 26th.
7 a.m.
October 26th, 2018 morning. Yes.
And what, if anything, was the call that you received?
I believe it was very generic. Couple dead bodies at the hospital being dropped off by a friend.
Why would you say it's pretty generic? Just a couple dead bodies. You're going to sound like a serial killer when you say that.
And just so you know, I don't get into great details when they call me out when I'm asleep because most of the time early information is not accurate anyway. So that's all I had is some semblance of what was going on when I headed to the hospital.
Wow, that was the worst first two question answers of all time. Good Lord.
And you specifically do that. You don't know too much so that you can get there and form your own.
Yeah, exactly.
And let me kind of ask you, at that point in time, what was your goal with the Miramar Police Department? I know you were a homicide detective, but were you kind of stepping back a bit because you were getting ready to retire?
Yeah, kind of internally within our team. We know when people are about to retire, and we try not to put them in really important positions in homicide as they get close to retirement for reasons like this.
7 years later,
Yeah.
come back to court.
Yeah, retired, and so. But yeah, I was definitely taking a back seat on a lot of things. I think that my saying was, I don't want to interview the shooter. I don't want to find the gun.
Excellent.
I don't want to interview the shooter. I don't want to find the gun.
So, what was your role when you arrived at the hospital that morning?
A team player. I wasn't the lead. Detective Moretti was. So whatever he needed,
And what, if anything, when you arrived, was Detective Moretti already arrived when you arrived?
he was.
What, if anything, did he tell you when you arrived in the hospital?
I don't recall specifically.
Did he ask you at some point to drive someone came to know as Bortlen Henry?
Yes.
What did he ask you to do with Bortlen Henry?
We were trying to locate the scene of the crime.
Why were you all trying to locate the scene of the crime?
Evidence, video, hard evidence, video, anything we could. So also, we want to make sure it's in our jurisdiction. That's like an important part. But no, we're just trying to determine where the crime occurred.
At the time when you drove with Bortlen Henry, was he a suspect in this case?
No, he's a victim.
You all at that point believed he was a victim of this drive-by shooting?
Yes.
So when Bortlen Henry got into your car, what kind of car were you all driving?
It would have been a detective car. I'm not sure if...
An unmarked?
Unmarked, yeah.
Would there be any cage in the back or anything like that?
No.
Do you recall where in the car he sat?
I want to say I believe he was in the front seat.
Next to you?
Yes.
What did Mr. Henry do with you in the vehicle?
He directed me to the location, and it seemed like it wasn't very forthcoming, and went back to the station. He was courteous. Wasn't, obviously I don't think he's cooperative in that situation, but
So there was no
Why is that obvious? Okay.
questioning back and forth between you and him?
no. Well, questioning
You just asked him where the... Okay.
is where's this location exactly?
That's the
Yeah,
question.
nothing about potential suspect or the investigative part. We're just trying to determine where it happened, what happened. It's very early on in the investigation.
I didn't ask anything, just, who, what, when, where, why, and how. But other than that,
So it was just a turn left, turn right, go straight.
And then this is where it's at.
that was my question.
Okay.
Was he at any point in time put under arrest with you?
That's not for
No.
him to decide. Come on.
Was he in your custody at that time?
That's not for him to know.
No.
That's not his question.
Was he at any point in time not free to leave? He had said, I'm done with this.
No, he's a witness. He can leave whenever he wants. Well, at the time, we believed he was a witness, so.
And so at that time, he was just there voluntarily telling you guys and showing you where this crime scene was.
Yes.
No further questions, Your Honor.
So whether somebody's in custody is a question of law. The detective's not qualified to answer that question. It's for the judge to decide, or the jury, in certain circumstances.
Okay, cross-examination, go ahead.
Thank you. Was he talking to you before he gave a statement to Bortlen and Moretti?
I don't know the timing of the statement he gave to Bertram Moretti, but if it was after I drove him around, then yeah, he was talking to me.
After?
No, I'm not sure. What was the timeline of his statement?
You had a crime scene, you said. You said you were investigating a crime.
Yes.
You said that on the record. What constituted a crime?
The 2 dead bodies?
Okay. So you,
That was a good answer.
what constituted a crime?
The 2 dead bodies?
Okay. So you
I'll give him that one. That's fair.
formulated an opinion on crime that occurred. So you had 2 dead
We were
That's
working
a fair
homicide, yeah.
Yeah, homicide. You were called out to a homicide.
Yes.
You had a person who was not dead, Mr. Henry, correct?
Correct?
Who was in the vehicle, correct?
Correct?
You're trying to ascertain what happened.
Yes.
Do you know whether or not police officers had already looked for the scene based upon what had happened with the guy, where he told another police, the lady at the hospital or another person?
I'm sorry. Can you say that again?
Whether or not he's in their encounter with the first police person on scene, that he gave a location for the shooting that was already investigated.
I don't remember.
You don't remember?
I don't.
You weren't told anything about where it may have happened?
I may have been. I just don't recall.
All right. So what did Moretti tell you? Take him and see if you can find something?
Yeah, he was even if, and I don't recall specifically, but even if somebody thought they were where the crime scene was based on what he had told them, we're still going to do a drive-by in person with him.
So you wanted to go back and look to see if
Phrasing? Are we not
Exact,
doing
yeah,
phrasing?
try to find the exact location of the scene.
and you drove
We're
there?
going to do a
Yes.
drive-by with him?
That was at the direction of Murray
Uh,
or Bertrand?
it's kind of a gray area at the direction. We work as a team, so yeah, it would have been Moretti is the lead detective.
You weren't the guy in charge, Moretti was.
Correct.
Because you were getting ready to retire.
That was the plan, yeah.
Yeah. So Moretti said, hey, I want you to take this guy and go see if you can find out where this happened.
Yep. Is that a question?
Huh?
Was that a question?
Yeah.
Yeah. Yes.
Okay, and so Moretti directed him to you.
What do you mean by that? Directed him to me.
How did you get into the police car? You said to him, come on in the car?
I believe it was mutually, it was discussed that he's going to show us the location of the crime.
This guy knows where the shooting happened. Take him and look for it, correct?
Sounds about right. Yeah.
Yeah. Well, who was you with, Moretti and Bertrand?
Not sure.
Where was he when you first encountered him?
I met him at the hospital.
Whereabouts in the hospital?
I don't remember.
Did you make any notes of where he was? You ever have that copy?
I do not.
Okay, so you put him in the police car and you drove him somewhere, correct?
Yes.
What conversations did you have with him? Do you recall any of them?
I don't. I'd have to listen to the recording.
You didn't record them?
Actually, I'm not even sure if it was recorded or not.
Okay, you were a homicide detective, correct? You were called out to a homicide, then you passed on to somebody else. You got an eyewitness to a homicide, and you don't recall whether you asked him any questions or not.
It was 7 years ago. That's
I'm sure I did talk to him. I just don't recall. If there was a recording of it, it'd be easier for me to reflect on that, but I can't tell you exactly what we talked about, other than we're trying to determine the location of the crime.
To try to determine what happened. Did you ask him for his version?
you know how hard it is to get me to like take the cop's side in these situations, but he's getting really close.
Of what may have happened to cause the murder?
I don't know if I asked him directly, but I'm sure somebody had asked him, and it may have been relayed to me.
We don't have any notes of that?
No.
Okay. Did you say there's recordings of that?
I'm not positive.
Were you wearing a body cam?
No.
Miramar didn't video in that?
No.
There's no body cams in any of this stuff, correct?
I don't know.
How long after this did you retire?
February 21, so 2.5 years?
All right. How long were you a homicide detective?
18 years.
After driving with Mr. Henry to the scene, to have gone through this, there was no scene. Did you have suspicions about his involvement?
Let's see. No, not as far as a suspect. Obviously, he's involved. He's there with the decedents. So we knew he's involved, but no, I think he was just being uncooperative. It's very common in my career that people aren't cooperative only because they don't want to get involved. So that's kind of the gist that I got from him.
You didn't want to get involved?
Yeah.
And you were trying to get him involved, of course, by asking him what happened, where it was, right? That's what a detective does, correct?
Yeah, I'm trying to determine the location of the crime scene, yeah.
This is dog water. This cross.
Okay. And you took him back from Moretti and,
Like, did he just ask a homicide detective if he's trying to get somebody who delivered these 2 dead bodies to the hospital, whether he wanted to get that guy involved in the investigation? Like, yeah, that's the whole idea. That's the core concept of what a detective does.
Bertrand, right?
I would have brought him back to somebody, yeah, I'm not sure who I saw
You
one.
rode where you thought you seemed like you didn't take him back.
Yes.
You didn't take him home.
No.
You didn't tell him you're free to go. Call somebody, we'll let you go now.
Not that I recall.
Okay. Thank you.
State, may redirect.
No, Your Honor.
Okay, Detective, I actually have a question for you.
Sure.
Let's say you drove out to wherever you were going, and right before you got there, Mr. Henry had said to you, hey, you know what? I changed my mind. I don't want to talk to you. I don't want to talk to anyone. I would like to get out of the car right now. What would you have done?
Let him go.
State, based on my question, do you have any additional questions?
No, Your Honor.
Defense, based on my question, do you have any additional questions?
You would have just let him walk out. Do you know what Moretti and Bortlen's intentions were?
No, I don't know their intentions, but no, under the circumstances, he used the word cooperating kind of in a gray area, but he was being courteous. He was somewhat cooperating, so he was free to leave at any time. He was free to leave at any time.
You guys, let me see. You've got two dead bodies. You're investigating a person who drove them to the hospital. You have a person who drove to the hospital. He's free to walk away. You're not going to complete an investigation.
Asked and
That's
answered.
your me.
Wait, yeah, I tried to complete an investigation, but he's free to walk away. He's not a suspect. He's not detained.
You want to find out what happened, right?
Of course we do, but we get lied to very frequently, so
Don't you keep people there to finish investigating?
no.
Your investigation?
No, I wish we did, but no.
Do you recall what your conversations were with Moretti or Bortlen about him?
I do not.
Just, if he had made, if he had been subject to any questioning by you, as an 18-year homicide detective, that you would have noted in your report, correct?
Yes.
So if at any point
Why
in
is she
time you
carrying her
had
laptop like
engaged in
that?
questioning with him or anything beyond just driving into the crime scene, you would have noted that in your report, correct?
Yes.
And that was not your role in this case, to question anybody, correct?
It was not.
You were, not to diminish your role, but like road patrol
Yeah.
officer at that point.
No, I was there for support. At that point in my career, I was not trying to get in the lead.
No further questions, Your Honor.
Yeah. How many police besides you and Bortlen and Moretti were there?
At the hospital?
Yeah.
I have no idea.
It was already a crime scene established there by the first people that arrived, correct?
I believe so, yeah.
Yeah, you had a big crime scene tape, everything else where the truck was. You had, what do you call those people who take pictures? Crime scene investigators there and everything?
Yeah.
They were all there. No question about it, correct?
When I showed up, I'm not sure they were all there yet. Because we're all getting called out.
Huh?
We're all getting called out, so
Called out the whole town, right?
I don't know who they called out. I mean,
You were all called, all the detectives were there. You know the crime scene people were there, correct?
I do not know if they were there at the time.
Isn't it the first thing that you do when you have a thing, something like that to establish a crime scene?
Like he's just saying that I don't know who got there in what sequence. He's not saying they weren't there entirely. This is pointless.
And you have a person to take.
You mean a crime scene log?
Huh?
You mean a crime scene log?
Yeah.
Yeah, we normally do that. I don't know.
You know when it was done, correct?
No, I actually don't know for sure if it was or not.
Okay.
He is, Your Honor.
Thank you, Judge.
State called Detective Mark Moretti.
Sir, if I could have you come all the way up here to the witness stand. Once you read.
And yeah, 16 years with credit for time served. I don't think he spent as much time in jail as Melly has, but it's not even 16 years. I don't know how long. I don't know how parole works there, but I mean, realistically, I don't even know if it'll be a decade. Which I mean is raises its own questions about the propriety of offering that kind of plea deal to something that's significant of a crime. It's kind of like admitting that you don't have enough evidence to bring the prosecution, but you don't want to lose. That happens in Fulton County a lot. I was going to do a video on this soon. I want to show this one really quickly. Show this one case. Miss Sylvia brought this to my attention. I was actually in Atlanta when she told me about this. Where are you? Here we are. This is literally just going to be like 2 minutes. It was this case here. Let me show you. This one right here. This was a double homicide. I'll show you the indictment, actually. These were the counts. So it's 1, 2, 3, 4, 5 gang counts. This is one murder case. One was murder, one was felony murder, but it was the same crime. 1, 2, 3, 4 ag assaults and possession of a firearm during the commission of a felony, which is 106, believe it or not. They got that one right. And the maximum sentence for that is, I don't know, like hundreds of years. Minimum life sentence for murder. They had nothing. There was no case. They kept him in Rice Street for 4 years, and the deal he got was 25 years to serve 10 with credit for time served. So at the time he took the plea, he'd already served 4+ years. And you're eligible for parole after like 2/3. So he had to do like another year before he was out on a case on a murder plus 4 or 3 other shootings. Which to me is like the prosecutors saying, we know we don't have a case, but we don't want to lose. So we'll give you a deal that'll get you out in a year. And not only that, it was a first offender. So he's not even going to have a criminal record in a year. I mean, it's already been half a year. So in another year or so from now, he's not even going to have a criminal record and he's going to be completely free. And, oh my goodness. That's a problem for me because I think it's tantamount to the state saying we don't have a case, but we don't want to lose. So we're just gonna give you a deal that's super favorable. This is their evidence. These Instagram DMs said on gang, so that means he's in a gang. And he has YFN in his name, so that means he's in a gang. Lil Jeff, I don't think that's Jeffrey Williams, but see, they call them gang. Where you at, gang? And then man, so that means they're in a gang. This is just kind of funny. I'm on Cleveland, hell nah, twin. Laugh emojis. I'm slime now, laugh emojis. More laugh emojis. That means they're in a gang. Twin, you at work? Hell nah. Hell yeah, twin. I'm bringing some weed back for me and you, twin. All right, and Rick them back. The giving back? Oh, the gang back. Say less. That means they're in a gang. This might be them in a gang. I don't know. But being in a gang is not even a crime, so this is just every Gen Zer. This is all the evidence they had. Okay, this guy might be a blood. I don't know. Just the red and the blood gang signs, but you know, this isn't very good murder case evidence. But yeah, that's another example of a case where, you know, keeping somebody in jail without bond leads to a conviction on a weak case. Where are we? Is it this one? It is not. This one? This one.
Before you have a seat, just stop and look at you.
I do.
So once you're seated, if I get you to scoot that
Sorry for that complete tangent, by the way.
forward as far as it will go.
I've been mad about that case for months. That was actually when I was in Atlanta that time. That was the time I went there to meet Miss Love with Tiffany, and then Love just ghosted us, and I just flew to Atlanta from Los Angeles for no reason. So that was a really good time.
Mark Moretti, M-A-R-K-M-O-R-E-T-T-I.
Thank you, Judge. Detective Moretti, where are you currently employed?
Employed with the Office of National Drug Control Policy through one of their initiatives called HIDA.
Of course you are. Oh, Jesus.
It's a federal agency.
And what is
The feds hired this guy. This dipshit.
High intensity drug trafficking area.
and how long
I'm going to start doing drugs just because this guy wants me not to.
have you been with HIDA?
Since January.
Prior to January, where were you employed?
City of Miramar.
In what capacity?
Homicide detective.
How long were you a homicide detective in the city of Miramar?
Almost 10 years.
And how long were you with the city of Miramar total?
22 years.
And prior to your involvement with the city of Miramar, did you have any other law enforcement or military training?
Yes, I was with the Village of Pinecrest Police Department from 1998 until 2003. Prior to that, I was in the Air Force, 1991 till 1998. Then the Coast Guard Reserves from 2003 until 2017. Served as well as listed as well as a commissioned officer.
So, well over 20 years of law enforcement experience at the time of this investigation.
Yes.
And now, on October 26, 2018, were you still working in your capacity as a homicide detective in the city of Miramar?
Yes.
What is the call that you received that night?
I was
When I say night, it was dark out early morning hours.
I was called to respond to Memorial Miramar Hospital reference a double homicide. Two individuals were inside of a vehicle that were apparently victims of a gunshot.
And did you yourself arrive at the hospital?
Yes.
What, if anything, were you told when you arrived at the hospital?
I believe when I got on scene, I made contact with the supervisor, then later got in contact with Detective Bortlen because it was his week to be on call, so he was technically the lead. He called me out because he was soon to retire in less than a year, and he did not want to pick up another case. And so I, agreed to come out and help him.
And when you arrived on scene, did anyone kind of brief you as to what was going on?
The on-scene supervisor briefed me. Then once I got with Detective Bertrand, he briefed me on what he had at that point.
And what were you told was going on at that point?
An individual arrived in the entrance to the emergency room. It was a gray Jeep. The gray Jeep was still there. There was two victims. Both died of multiple gunshot wounds. Then they were later transferred to inside the ER. I believe that's where they were officially pronounced deceased, was inside the ER. The vehicle was still there. It was secured so no one can go in or out of it. Nothing could be touched like any other crime scene. And that's all we had at that point. That was technically our crime scene, even though we didn't know where this incident had occurred. We just knew that this vehicle came to ER with two dead bodies.
Now, this individual who came to the ER with two dead bodies, who was that person?
It was Cortland Henry.
And do you see that person in the courtroom today?
Yes.
Can you identify him by an article of clothing in his location?
Red jumpsuit sitting next to Mr. Haddad.
You can't tell he's wearing a jumpsuit because you can't see beneath his chest. He's just saying red jumpsuit because he already knows that that's the guy. Why say red shirt?
And by this witness.
The record shall so reflect. You may proceed.
How did you first come into contact with Mr. Henry?
He was in a treatment room. He was laying in a bed, wasn't handcuffed, wasn't under arrest. As far as we knew, he was technically a victim and the only surviving witness of a double homicide.
So when you walked in to speak to him, how did you introduce yourself?
It was recorded. I think I just gave my first name or said detective. I had to listen to the recording, but I had a polo shirt, regular slacks on, gun on my side, ID, badge.
You stated he was in the hospital room unrestrained. Was there anyone guarding the door to the room or anything like that?
The best of my recollection at this time, I don't think there was anyone guarding the room. I mean, there was a lot of police presence there that day. There was probably half the west side was over there. So
So when I say guarding the movement, as far as you were concerned, he was free to leave that off.
He was just as witness. We didn't have anything we couldn't detain him. We couldn't compel him to talk. If he didn't want to talk to us, we couldn't compel him. He was just a witness at that point, a victim.
And the judge has already listened to it, has already evidenced that statement. What was his demeanor like during that statement?
It was I would say a cordial conversation. He was upset. His friends were just murdered in front of him. But there was no hostilities, no arguing back and forth, no profanities or anything like that.
At that time in your investigation, was he considered a victim of this crime?
Technically, he was a victim because he was shot at.
And so was your questioning at that point in time not for incriminating information, but more of how did you end up in the hospital with 2 dead bodies in your car?
The biggest issue we did not know where this crime occurred. When it initially started off, we didn't even think that this even occurred in our city.
Why is that?
We didn't have a crime scene. What we were being told of where this occurred, we received no phone calls of shots being fired. There was no spent casings, no glass on the road. There was no indication that any crime occurred anywhere in Miramar that day.
And is that why, at the conclusion of your statement, Mr. Henry, you asked him if you would be willing to actually direct one of your officers, to where it happened? Because from the location information he had given to you all at that point, it wasn't matching up.
No.
Figure out where it was.
Even in his statement, he says, "I'm not from here. I'm not familiar with there." So we gave him the benefit of the doubt. Like, okay, people get lost all the time. They might think they're on Miramar Parkway, but actually on Pembroke Road or Pines Boulevard. It's understandable. So we said, you know what, just ride with Detective Toyota and show him where it happened.
And did he say, sure, yeah?
I don't know his exact words, but he didn't object. He wasn't in handcuffs. And it was an unmarked police unit, not a cage in the back of that car. So
If he had said, no, I don't want to do that, what would you have done?
there's nothing we could have done.
Throughout your statement with Mr. Henry, did he ever say, I don't want to speak to you?
He never invoked his Fifth Amendment rights.
Even outside of invoking his right, did he ever give you any indication that he did not want to speak to you? Did he say, I don't want to do this right now? Or did he say, I'm not?
Did he say?
Never invoked his Fifth Amendment rights.
Even outside of invoking his right, did he ever give you any indication that he did not want to speak to you? Did he say, I don't want to do this right now? Or did he say, I'm not comfortable? Did he say, can we do this later?
No, every question we asked, he answered. Might not have been the most truthful, but he answered every question.
And after he did this drive-by, was that kind of the end of your interaction with him at that point?
At that point, yes, ma'am.
All right, I want to do another quick segue, or I don't know, tangent, because I don't know, it's Friday. Let's have fun with it, right? Since we're talking about interviewing people in hospital rooms, I thought we could take a trip to Atlanta and visit with our... Wait, is this the right one? That'd be embarrassing if it wasn't. I think I had the wrong Hogan. Okay, we're coming back to this one. I could get the right Detective Hogan. That's my bad. Give me a second.
Now, after that drive-by, did you then go speak with Mr. Henry at another point in time?
There we go.
I'm sorry, can you say that again?
After that initial statement with him at the hospital, did you then speak to Mr. Henry at any other time?
When he was arrested in Houston, we did fly down to Houston to try to speak with him there, but he wouldn't speak with us then. He definitely invoked his right there.
And not because at that point in time he was a suspect and wasn't under arrest.
Correct.
Nothing further, Your Honor.
Okay, cross-examination.
Okay, I got the right one this time. We are slime, Aaron. We are slime. Here we go. This is State versus Franklin. This features our good friend Detective Hogan. Some of you may remember from the YSL case. Let me see. I want to make sure this isn't too long. I don't want to spend too much time on this. Okay, yeah. So it's only like 4 pages. Okay. Appellee DeQuavius Franklin was indicted for murder of Jaquan Anderson. Filed a motion to suppress. He challenged the introduction of the statement he made to law enforcement while in a hospital on January 4th, 2022. The state filed a corresponding motion in limine to adjudicate the admissibility of the same. After the trial court granted the motion to suppress, he made to law enforcement on the basis that the statement was not voluntary due to appellee's medical condition, and circumstances surrounding his physical condition. The state appealed pursuant. That's the state's right to appeal in a criminal trial. The state contends that appellee's statement was voluntary. We agree because no evidence in the record shows that law enforcement coerced this statement and accordingly reverse. So, preponderance of the evidence, state bears the burden of proof. The appellate court must construe the evidentiary record in the light most favorable to the factual findings and judgment of the trial court. De novo review means they take a fresh look at it, but I just want to read the circumstances mostly. Okay. Viewed in this light, in the evidence in the record and presented at the Jackson Deno hearing showed the following. The arrest warrant affidavit recited that on December 31st, 2021, Detective Al Hogan with the APD responded to a 911 call reporting a shooting and armed robbery by 2 masked assailants at a residence in Fulton County. Detective Hogan discovered Anderson's body lying in the main room of the residence and noticed a large amount of blood on the opposite side of the room from Anderson, as well as a black ski mask on the floor near his body. Detective Hogan deduced that the blood on the opposite side of the room did not belong to Anderson, and subsequent investigation led Detective Hogan to believe that Anderson fired shots during the robbery and injured an assailant, and that the injured assailant fled, leaving the blood and ski mask behind. Detective Hogan learned while responding to the 911 call that someone wearing a black ski mask delivered appellee to Emory Hospital, and that appellee was suffering an abdominal gunshot wound. So, it actually makes some sense that this is the suspect, but again, it's going to get to admissibility and voluntariness of the statement. Appellee's medical records were introduced at the hearing, but there was no testimony offered about the records. Those records show that Emory transferred appellee to Atlanta Medical Center for surgery to remove his spleen, left kidney, and pancreas, and to repair his abdomen. AMC, the hospital, administered propofol, fentanyl, and other medications to appellee for anesthesia and pain relief. On January 3rd, 2022, appellee underwent a second surgery due to respiratory failure and blood loss anemia and received nourishment through a feeding tube. Detective Hogan testified at the hearing that during his investigation, he narrowed the suspects down to appellee and a second unidentified person. Detective Hogan obtained a search warrant for DNA, reasonable, and on the 4th, he obtained the permission of hospital staff to interview appellee and did so in his hospital room. The interview was audio recorded. Before the interview, he made efforts to make sure that appellee was physically, mentally capable and well enough to speak with him during the investigation by contacting hospital staff. Not the guy actually making the statement. During the interview, only Hogan and the appellee were in the room, although nurses occasionally entered and exited. So it's just the two of them, and the defendant was he just recovering from multiple surgeries. He was on fentanyl. He was given fentanyl and propofol, which is another anesthetic. And there's a guy he didn't know with a gun in his room, and he couldn't get out of bed. And he's being questioned about a crime. Detective Hogan testified that appellee was not under arrest at the time, that he had not obtained an arrest warrant, that appellee was not in handcuffs. Well, yeah, he's in fucking hospital bed because he just had his pancreas, spleen, and kidney taken out, and he was on fentanyl and propofol, and he had blood loss anemia and had a feeding tube. So the handcuffs wouldn't really be particularly needed in that case, given that he probably can't fucking move. In any event, that neither appellee's hands nor feet were bound together. No, he just can't move them. Detective Hogan further testified that he believed that Apelli comprehended English, understood the questions, and answered the questions. Well, yeah, of course he's going to say that. Before leaving, he executed the search warrant for Apelli's DNA by obtaining a buccal swab. He intended to seek an arrest warrant for Apelli if the DNA results placed Apelli at the crime scene. Medical records showed that Apelli remained in the hospital until January 19th, so he didn't even get out of the hospital for over 2 weeks after this. But he wasn't handcuffed, so, According to Hogan's testimony in the affidavit, he later learned that the DNA at the crime scene matched that of Apelli. Again, the guy's probably guilty. Don't get me wrong, but that's not really the issue here. Following the hearing, the trial court granted the motion to suppress. In its order, the trial court considered the testimony of Detective Hogan set forth above, referenced the medical records, and concluded, based on this medical history, it is readily apparent that the statement the state is attempting to admit should not be admitted, as Mr. Franklin was in no physical or mental condition to give a knowingly voluntary statement or waive his Fifth Amendment privilege. Good judge. Due to the medication the defendant was receiving, his medical condition, and the circumstances surrounding the defendant's physical condition, this court exercises its discretion and finds that the statement was not voluntary and is inadmissible in the trial of this case. So far, so good. Surely it's not going to get bad. The state argues that the trial court erred in excluding the statement on the ground that it was not voluntary. We agree. So yeah, the appellate court said that they've reversed the trial court and found that the statement was admissible. Although the issues of whether Apelli's statement was involuntary under 24S, the evidence code, whether he should have been notified of his rights under Miranda, were raised by the parties. The trial court's order does not expressly make such rulings, and we do not read the trial court's orders making those determinations. Means that a confession or inculpatory statement be the product of a rational intellect and a free will under the totality of the circumstances. The Supreme Court of the United States has held that coercive police activity is a necessary predicate to a finding that a confession is not voluntary within the meaning of the Due Process Clause. So basically they're saying that because he didn't, coerce, Hogan didn't actually coerce the defendant, it was voluntary. Even though, propofol and fentanyl, as Lexi says, the good drugs. Hey, Nick. So, yeah, that was Al Hogan was interviewing somebody who just had their spleen, pancreas, and kidney removed and had blood and loss anemia and a feeding tube, but his statements were voluntary. Okay, back to Melly. Thank you for indulging my my little aside there. This one? This one.
Good morning, sir.
Now, let me see. You said when you got there you already had a crime scene, correct? At the hospital?
The car was secured.
That means there was evidence tape on it and all that stuff?
I'd have to refer to the crime scene photos, but I believe they did put crime scene tape up around the vehicle. I'd have to look at the photos.
All right. Was crime scene investigators there from your department?
Yes,
They were already starting their work?
I believe so.
What time did you arrive?
About 6 o'clock.
In the morning?
Yes, sir.
And how long Mr. Henry been there?
I believe he got there, at 4:35?
So that's an hour and a half. How many cops were there?
You would have to look at the crime scene log, but there was a significant amount.
What do you mean by significant?
Well, it is.
Is it Washington right now?
I don't think that many. The only truly way to answer that question is look at the crime scene log to see who was there. I don't want to give you a number, be wrong, but.
Let's say it was a significant police presence in the hospital, correct?
Yes, sir.
You had 2 dead bodies and you had an investigation going on. You had crime scene there. You had the vehicle involved right there, correct?
Yes, sir.
Mr. Henry was sitting down in the hospital.
He was in a room with a hospital bed. The heart rate monitor was on him. Basically, looked like he was receiving treatment.
What kind of treatment?
the hospital's protocol. You have to ask him why. He was just a victim of a shooting. I guess they wanted to check him out.
Was he shot?
He was shot at.
But there was no physical injuries that he was there, correct?
No, sir.
Did anybody report any physical injuries?
No, sir.
He was in a hospital.
Yes, sir.
Was he handcuffed?
No, sir.
Okay. Now, you talked to the other detectives and we found out you were at the crime scene. You fired where it occurred, correct?
Correct.
And you went to talk to Bortlen, Henry, correct?
Yes, sir.
And you say this, you say cordially, if I may, and you first words with Henry. Hey, how you doing? What's up, man? How you guys doing? You say, hey, my name is Detective Bertrand, and this is Detective Moret. I can't talk. We're here to talk to you about what happened, okay? That's not the same, right?
Yes, sir.
Now, the police say to him, all right, listen, you need to be straight up and tell
Yes,
us
sir.
where this happened. Okay? My understanding, you told these officers something, but the evidence doesn't show that it happened, correct?
Who said that?
Bertrand,
Okay.
correct?
Correct. I got the statement in front of me.
Third line down, fifth line down, the evidence doesn't show it happened. You gotta be straight up, correct?
Yep, that's fine. Yeah, you're right, sir.
Yeah, the evidence doesn't show that happened. You're confronting him with the fact that he's misrepresented something to the police, correct?
Yeah, but-
Because you're saying it doesn't add up, correct?
Correct.
You're confronting him, now that's obstruction of justice, isn't it?
No.
Listen, did you testify in the trial that you had enough to arrest him at that time? You
I-
testified to Mr. Alstein that at that time you had enough to arrest him. I can find the transcript.
I would like to see the full transcripts on that because I don't remember specifically saying that we had enough.
I enjoyed that face. I want to watch that again.
At that time, you testified to Mr. Alstein that at that time you had enough to arrest him. I can find the transcript.
I would like to see the full transcripts on that because I don't remember specifically saying that we had enough to arrest him at that time
Yeah, okay.
at the hospital because we didn't even know if this crime even occurred in the hospital. So for you to come in here and say that, it sounds like you're trying to put words in my mouth again.
Okay, you give me false information according to you, right?
He is giving me false
That's a
information.
crime.
It is. It's a misdemeanor.
You've got two dead people and he's giving you false information. You confront them with the fact that he's giving you false information, correct?
Sir, I do not want to arrest on a homicide for a misdemeanor charge, and then we got the speedy trial
You
issues.
want to arrest for a misdemeanor.
I don't want to have to worry about giving somebody a speedy trial.
Okay. You want to arrest for something more important, correct?
Correct.
Yes. And you're telling him he's lying to you, correct?
Correct.
Okay. You're accusing him of committing a crime. And how many policemen were around?
In that room was just Detective Bertrand and I.
How many were out guarding the room, guarding the hospital, meandering around doing whatever you cops do?
I could not answer that question because I don't know who was where, was walking
There
around.
a dozen.
You would have to look at the crime scene log, sir.
You don't have any video of it, do you?
No, sir. There was video outside the hospital where when the bodies were brought in, but I think that there's no video inside the ER room for HIPAA reasons.
So after you tell him that,
I'm sorry, the caption saying HIPAA reasons is just golden.
you continue to talk to you, correct?
Correct.
You continue talking about you need to know where the scene was, correct?
Yes.
And you direct him, you asked him to go with Bertrand, correct? Toyota.
Yes.
How did you ask him?
You'd have to refer to the statement.
No, I'm asking you. You tell me how you asked him.
Would you mind showing Detective Toyota where it occurred?
You already know you lied about where it occurred.
Like I said in the direct examination, I said that sometimes people get confused. Miramar Parkway, Pembroke Road. So
You say that to him?
no, sir.
That was in your mind. Maybe he was confused.
Correct.
You were having him go with a detective for what?
To point out the location where
You
the
already committed a crime. I'm just representing. Was he free to leave?
Well, if you looked into our statement, we even told him, listen, we don't care about the drugs. We don't care about any other crimes. We only care about the dead bodies. I am not concerned about a misdemeanor lying to me.
But that's part of homicide investigation where it happened, correct?
The people,
But lying to you about where it happened, that can feed your investigation.
sir, every single homicide investigation we had, people lie to us. It is a part of our job, day in and day out. People lie to us, and we understand
You
it.
let them all go, correct?
And then he lies to the court. It's like it's a cycle that he does.
No, sir.
Okay.
But people lie, we understand it, we accept it, and people lie to us for different reasons. You know, we didn't know he lied to us because he was involved in this homicide. We just figured he lied because they were doing something and they didn't want to tell the police about it. That was kind of our understanding. But we didn't feel that this even happened in Miramar. Oh, of course. I mean, what investigator would not confront them when the facts don't add up? I'm sorry, sir. I'm sorry.
Yeah, you confronted them with the fact you died in one, correct?
Correct.
Thank you. I'll let it go. Thank you, sir.
Based on that, you read.
Detective Moretti, when you all are telling him the evidence doesn't show that happened, was that saying, we think you committed this crime, or was it saying, after you testified on direct, we can't find this crime scene, where is this crime scene?
Correct.
And when the defense counsel keeps saying, he lied, he lied, he lied, we all know he lied throughout that statement. But in your mind at that point in time, was it, this man is committing perjury by lying to me, or was it, as you said before, he doesn't know the city of Miramar, doesn't understand what road this is, and isn't able to properly tell me where this happened?
We were not thinking that he was involved in this crime whatsoever.
And in fact, at the end of that recording, didn't you all even offer to drive him home?
I'd have to refer back to the full statement, but
If that would refresh your recollection. I believe it is the last sentence.
I mean, like I said, it was not a confrontational encounter. I don't know if I have the full statement here. Can I see your version?
Are they different versions? Does she give a different report? Yes.
Okay, it says, question was actually from,
It was actually from Bertrand, and it says Hector offered him a ride home.
And is that something that in your practice you all would oftentimes do when people are not in custody?
We've never given a criminal ride home, so.
What do you mean? You drive yourself home every night?
Further questions, Your Honor?
Based on that, you recross.
I got that one other question too. Based on that, you've never given a criminal ride home. You ever given a suspect a ride home, build up evidence to make an arrest later when you were a suspect?
If I was concerned that they were a suspect of a homicide, I am by no means going to get into a car with them and drive them somewhere for my safety alone.
That's a fair point.
So you've never done it?
No,
Let me ask
sir.
you a question. This person that was just considered a victim, it's a gunshot resident from, correct?
Correct.
That's what you always do with victims?
Well, we were just trying to figure the case out. He wasn't telling the
The
truth.
case was you had accused him of something and he took gunshot residue. What other criminal investigation did you have?
We do that all the time. No, DNA would not have been possible. But we do that in almost all cases, just to rule him out.
Rule him out as a suspect. Because he was a suspect at that time. He was
No,
involved.
he was not a suspect at that time. We had no idea, no indication whatsoever. And even
This guy
then,
has better
when we
reaction
did
than I
the
do.
GSR, which there's two different types of GSR tests,
Yeah, they're both BS.
suspect at that time, we had no idea, no indication whatsoever. And even then, when we did the GSR, which there's two different types of GSR tests, the first one is just a presumptive test, and it's done after the initial test. And that just tells us if he handled the gun. That first test came back negative, which
No, it
even
doesn't. No, it doesn't. A GSR test just has for certain types of particles that can come from a variety of sources. You can't tell whether you handled a gun based on a GSR test. That's ridiculous.
in our mind a little bit more that he was not involved in any of this.
All right. You were doing investigative stuff, right?
Yes.
That's part of your protocol to take GSR?
Oh, we've done it many times with witnesses and stuff on case victims. That's nothing unusual.
What if they refuse?
Then we don't take it. We ask. The crime scene technician asked.
Okay.
If I ever have a client that voluntarily takes a GSR, I'm going to kill them. And after I kill them, I'm not going to take a GSR test.
A crime scene technician went up to him, asked him for gunshot residence
Yes, sir.
test. Was that at your direction,
I did not direct it, no.
Bertrand?
I do not know.
You was under your presence?
I was there when it was done.
You were there?
I was there.
How many other detectives, cops were there?
I couldn't even answer that question. At least Hector and myself and Detective Bortlen.
So he was in the presence of these three?
Well, it is outside the scope, but over your objection, go ahead.
There was 3 or 4 policemen with him, asking him to give him to let them test his hands, correct?
Correct.
And he thinks he's free to leave?
I can't testify to what he was thinking, sir.
What were the conditions of what a normal person would think, surrounded by police? Is he free to leave?
Well, yeah, I'll sustain that one. I think that's the question. Any other questions?
No. Well, thank you, Judge.
Okay, state witnesses.
He is, Your Honor.
Thank you, Your Honor.
Real quick, 5-minute restroom break for the court. We'll be in recess for 5 minutes.
You will read this for evidence, right?
Huh?
The audio, you will read that as evidence. You don't need to read that for evidence. Just before we let him go.
I'll do this on the record, but actually probably.
Yeah, I will. That's why I was like, wait a second, you didn't.
Look at that wall. We're going to come back, right? There's like a whole guilty plea thing? Plea deal? A bougie. Oh, hey, Kat, the, what is it? The blah, 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 the rally thing. Is that still happening, or did that get pushed? That's on Monday, right? Just as Judge Head just appears. I want to get the exact moment there. Hold on. Exactly. Exactly.
Well, at this time, Your Honor, the state removed what has been already provided to Your Honor.
Let me go back on
He's already got it. It's labeled up there.
All right, let me go back on the record. This is State versus Cortland Henry, 19-1871 CF10A and 23-10643 CF10A. I continue to have Ms. Collins, Mr. Griffiths present for the state. Mr. Haddad present for Mr. Henry, who continues to be present. State, yes.
As a formality, the state removed at this point what has been provided to Your Honor previously. In reference to State's Exhibit 1, it's the 2 clips that Your Honor already talked about audio files that the state already discussed, that Your Honor reviewed by stipulation of the parties completely introduced that as evidence.
If there's any objection. All right, without objection, Ms. Wilcox, we'll call this State's A for identification. It's going to be in evidence only for the purposes of this hearing. That's State's Exhibit 1.
I had talked to the state because I had had repeatedly that they might vote kind of stuff about doing arguments tomorrow.
We have no objection to that. So.
That's fine.
And I may put them on.
That's fine.
but I can't talk, I'm gonna give it.
State, you have no other evidence or witnesses or testimony you want to present today.
No, Your Honor, just argument.
And Mr. Haddad, whatever evidence, witnesses, or testimony you want to present, you want me to do that tomorrow? Okay, that's no problem.
I also, with the state motion, extreme stuff,
Oh,
he said, you know, like, I don't know.
we filed the state's motion for relief from the trial order.
Yeah, to file your motion in limine.
Correct, but I think we agreed that that's moved because he doesn't intend to call.
The two witnesses. All right, I'll handle that when we do the arguments tomorrow.
Just so Your Honor knew it wasn't something that was
Understood.
heavily litigated.
Yeah, that's fine. So the only thing I'm going to press pause on the all pending motions. And again, we're going to resume tomorrow at 9 o'clock. That's the defense motion to suppress. I'll give you a ruling on the state's unopposed motion for relief from the trial order, as well as the state's motion in limine. But I'm going to let each side continue to present whatever evidence, witnesses, or testimony they'd like to do before that. So I'm going to pause on the evidentiary portion today. I do want to have a quick conversation with Mr. Henry. I'm going to put him under oath, talk to him about the charges, make sure he understands the maximum possible penalties, make sure he understands the state offer.
I think that's something else the defense wants to speak to him about tonight.
Yeah.
Well, I'm going to put it on the record right now, but he doesn't have to tell me what his answer is now. But I just want to make sure he has all the info. And what I'll tell you all, I'll be back here tomorrow, and then, you know, I'm going to tell Mr. Henry this as well, but for his benefit now, if he wants to resolve the cases by way of a negotiated plea, that's fine with me. And if he doesn't want to, that's fine with me too. But the one thing that I am going to change, if you need me to, I can put him on maybe Tuesday afternoon, the 9th. I'd rather just not do it. I'd rather know yes or no the day before, because there's a significant, number one, I don't want him to feel any pressure. But number two, I got 250 citizens coming in here Wednesday morning, and there's
Tuesday
just,
afternoon is fine, Your Honor.
yeah, if need be.
I have a hearing between 3:30.
It's fee hearings, you know.
Yeah, so I don't really have to say.
But I'm going to be here, right? Okay. All right, so Mr. Henry, listen, I'm going to put you under oath and ask you some questions, okay? It's only going to be as it relates to the state's offer, and it's only as to make sure that you understand the state's offer and you understand the charges that you're facing here. We're not going to talk about anything else. So just listen to my questions and answer the questions, okay? Raise your right hand. You swear to tell the truth, whole truth, nothing but the truth. Okay, you can put your hand down. Please state your full name. How old are you? How far did you go in school? Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? All right. How are you feeling this morning? Your head is clear? You understand what's going on? All right, so Mr. Henry, listen, you got two cases. I'm going to go one at a time. In case number 19-1871 CF10A, right now, you're charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital felonies, which means it's a mandatory life sentence. If the jury convicts you of count 1 or count 2 as charged, that's life in Florida State Prison. I have no discretion. Count 3 and count 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty for each of those is 30 years in Florida State Prison. Okay? In your other case, which is case number 23-10643 CF10A, you're charged as follows. Count 1 is tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. All right? As the maximum.
Wait, really? That's crazy.
Penalty. Count 2 is directing the activities of a criminal gang. That's a first degree felony punishable by life. So the maximum penalty there is also life in Florida State Prison. Count 5 is conspiracy to commit tampering. And again, as it's charged, that is also a life felony. The maximum penalty is life in Florida State Prison. And lastly, count 7 is unlawful use of a two-way communication device. As that's charged, the second degree felony. The maximum penalty is 15 years in Florida State Prison. So right now, as to all the charges that you're facing, the maximum possible penalties are as follows. It's life in Florida State Prison, followed by 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 75 years in Florida State Prison. Do you understand the charges and the max?
I need to. Was that 5 lives? Was that 5 lives in 75 years? 1, 2, 3, 4, 5, 36. Yeah, 5 lives and 75 years.
Maximum possible penalties involved. Okay. So, Mr. Henry, the state is telling me that they're extending an offer to you, and the offer is as follows. In case number 19-1871 CF10A, they're going to null process or drop counts 1 and 2, both first-degree murder charges. Okay. And in exchange for that, as to counts 3 and 4, in that case, the accessory after the fact to murder in the first degree, you're going to plead no contest to both of those. And as to the 4 counts in case number 23-10643 CF10A, you're going to plead no contest to all 4 of those counts.
Okay, I just need to write this down. So the null processing the murder counts, he's going to no contest accessory after the fact. And then he's going to no contest everything in the second case? Okay.
And in exchange for all of that, the state is offering that I would adjudicate you guilty and sentence you to the bottom of your sentencing guidelines, which is 195.45 months, about 16, it's a shade over 16 years and 3 months. 16 years and 3 months. All of those sentences will run concurrently, that is at the same time with each other. I would give you credit for all the time that you have served. Understand?
Wait.
16 years and 3 months. All of those sentences will run concurrently, that is at the same time with each other. I would give you credit for all the time that you have served, understanding that you have a lot less credit time on the 23 case because it's a newer case. So that is what would be controlling. Whatever credit time you have on the 23 case, you can subtract that from the 100
I think he actually has more time on the 23 case than the 19 because he's out of custody.
Oh, okay. Well, whichever case you have more time, less time in custody, that's what would happen. And you get the credit for all the time that you've served. And again, that sentence would be 16 years, a shade over 16 years, 3 months in Florida State Prison. I would have to order restitution. The state would tell me the amount of that restitution. That restitution would be joint and several with any of your other co-defendants. If any of the other co-defendants were convicted at trial or entered pleas. In other words, the restitution.
So joint and several, so that means Melly's going to be the one paying it.
It only has to be paid once, but each person is responsible for 100%.
Oh, I should say joint and several means that both he and Melly would independently be liable. You can collect from either one of them for any damages. And they're both entirely responsible. You can collect from either one. You can only collect up to the total amount, though. You can't collect twice. You can't collect from both of them. But obviously Melly's the wealthier one, so he won't be paying the restitution in all likelihood.
All right, but as soon as it's paid, it's paid. I would have to impose mandatory court costs in each case, and I would have to impose a mandatory cost of prosecution in each case, which is $100. So,
again, $100 is a deal breaker.
Mr. Henry, do you understand the offer that the state is making to you? Okay, the 16 years, 3 months, and a shade more. So I'm going to pause on it at this point, Mr. Henry. It's going to give you some time, whether that be tonight or also over the weekend, to talk to your lawyers about it, make sure they answer all your questions, talk to your family about it so you can make a decision as to what you want to do.
Let's talk about Moonton for a second. You see that? He's like, I'm going to give you the nighttime. You can talk about your family with it. You can think about it over the weekend. Not, we're going to start talking about it in November, and then I'm going to make you an offer on the night of December 27th, right before your plea hearing on the 28th. Awesome.
Now, let me explain this to you, sir. I can't make the state make you an offer, and I can't make you accept any offer. I'm just the referee, okay? This is a business decision between you, your lawyers, and the state. And if you want to accept it and resolve both cases that way, that's fine with me. And if you want to have a trial in both cases, that's fine with me too. It doesn't matter to me in any way, shape, or form. But whether it be tomorrow, when I see you tomorrow, and then Ms. Wilcox, he already has tomorrow at 9 o'clock, that'll remain on. But I'll put them on both cases as well next Tuesday, which is September the 9th. Let's just call it 1:30 in the afternoon. September the 9th at 1:30 in the afternoon. We'll call it trial status in both cases. That's when we're gonna have to finish this conversation, Mr. Henry, and you're gonna have to tell me that either that you understand the offer that the state's making, that your lawyers have answered your questions about it, and then you're gonna have to tell me what your decision is, whether you want to accept the offer or whether you want to reject the offer. Mr. Henry, the one additional thing that I like to talk to people who are sitting in this situation that you're sitting in right now and have this conversation is as follows. The reason that I'm doing this is because I want the record to be clear what the state's offer was, and the record to be clear that you understood it and that you had enough time to talk to your lawyers about it. You had enough time to talk to your family about it. You weren't under any pressure to make a decision, whatever you thought was in your best interest. Because it goes kind of like this. And I'm sure your lawyers could speak to it better than I can. If you accept the state's offer, that's fine. And again, if you don't accept it, that's fine too. But if you don't accept it, and one of these trials doesn't go your way, and you end up with life in Florida State Prison, which is a mandatory sentence on a lot of these counts, usually people in that situation, then they'll file what's called a motion for post-conviction relief, and they'll say, hey, Judge, my lawyer never told me. I didn't know that I could resolve all this for 16 years and 3 months, and if they would have told me that, I would have done it. And now I'm sitting here with a life sentence. So that's the reason I'm having this conversation now, so the record's going to be crystal clear on that issue. If it doesn't go your way, that argument's not going to be available to you to come back and say, hey, my lawyers didn't tell me about this, or I didn't know about this, so that's why I'm talking to you about it now. So, Mr. Henry, do you have any questions for me about the maximum possible penalties involved and what the state's offer is to you as we're talking about it right now? Okay. All right, so I'm going to pause on that part of the conversation, and we'll finish that other part of the conversation either tomorrow or next Tuesday afternoon. I'm going to leave you on for tomorrow, all pending motions, which is September the 5th at 9 o'clock. I have one other matter that I need to handle prior to that with Mr. Gibson and Mr. Percio. I don't imagine that's going to take too long. And then I'll be right with you all tomorrow. And then Ms. Wilcox, we're going to put both of Mr. Henry's cases on Tuesday, September the 9th, 1:30 p.m. We'll call that...
Yeah, Kat says, I feel like this is pressure since it implies there's no room for reversible error anymore. Yeah, I don't like the way he phrased it. Like, I get why he's saying it, but he probably could have said it in a better way.
Trial status, and he remains set for trial.
Like, the argument is still available to him. He's not going to win. But, you can still litigate it. No. Yeah, that's basically what Hines, what he did. I mean, like, substantially it's true, but he shouldn't have said it that way.
In both cases on Wednesday, September the 10th at 9 o'clock, understanding that if we go forward with the trial, it's going to be on the murder case, the 19-1871 CF10A. State is...
Kat is right again. I also think it's important to say, because you never know, someone's dumb friends are like, decline the plea and then appeal it if you lose, bro. Yeah. That was well put.
Is there anything else that you need me to do regarding Mr. Henry today?
There you are.
Mr. Haddad, anything else you need me to do regarding Mr. Henry today? Okay. All right, so we'll press pause at that point. Mr. Henry, I'll see you tomorrow at 9 o'clock, which is Friday, September the 5th. Ms. Wilcox, does that otherwise conclude the FT docket for today?
Yes.
Okay. So the FT is otherwise going to be in recess until tomorrow, which is Friday, September 5th at 8:45 a.m. I hope you all have a good rest of your afternoon. All right, Mr. Court Reporter. That is it.
All right, next we're going to switch to some legal advice. This is actually the hearing today, the September 5th hearing. Copyright strike by anybody in YSL. I'm going to be making some phone calls. I'm snitching. I'm going to snitch. I'm going to snitch my ass off. Okay, no more of that. Oh man, where are we? Is this is today's. Oh, why isn't this full screen? Oh, let me see here. Why is it doing regular full screen? That's so weird. Why is it doing regular full screen? There we go. Okay. So, I don't know. Let's see. How long is this one? Is this one a long? Was this a lot? Wow, this is a lot of wall. This is like 80% wall. What am I looking at here? Are you guys seeing this? You guys aren't even on the right screen. I gotta fix this. I was just talking to you about everyone else was snitching. Brenda D. She is, I gotta say, Brenda Foreman, she is on top of it. Try a lot and beat it thrice. That's a good call. Look at all this. Are you guys seeing this? See how much wall there is? I feel like this whole hearing is going to be like 20 minutes. Oh, and yeah, I saw what Mel said about first trial was so heavily tied to gang affiliation, where the jurors said that scared the jurors while deliberating. I'm interested to see the pivots they make in this trial. Yeah, totally. I think some of the stuff got struck, right? Some of the gang stuff. The Danny Polo stuff. I think a lot of that got suppressed, right? In the what was it? In the Detective Moretti, I don't know, whatever it was. The 13 things that got suppressed in I think January, February of last year, maybe. Something like that. Danny Polo, dipshit Danny, I can't deal with that guy. He doxed himself and then complained about getting doxed.
On the return on the order to show cause for witness Erica Lugo to appear in this courtroom in front of me at 8:45 a.m. Mr. Percio, I did read everything in the court file. I saw all the pleadings that have been filed. Is Ms. Lugo here this morning?
I have spoken to her. She said.
Let's put your hand up. Oh, all right. So that being the case, it would probably be my intention to continue the hearing at this point. Mr. Gibson, we got the witness present now. You can call the witness, ask whatever questions you want.
Thank you, Your Honor.
Would you like the time to sit over there with you?
When, Your Honor.
Okay. Mr. Baker, you can go over there and sit with your lawyer.
How's this thing sound, Wes? It feels kind of loud.
All right, so let me dispatch with the rule to show cause first, and then we're going to resume the hearing. Ms. Lugo, can you step up here real quick?
This looks like a different lawyer.
Good morning. You're Erica Lugo. So, Ms. Lugo, listen, that you did appear. So, at the end of the proceedings this morning, I'm just going to dismiss all this. That's going to be done.
Aaron says, yeah, there's rumor that he's running around telling people Raven Liberty was stalking him and put a hit on him because of his wife's Cash App picture. Raven Liberty, I don't think she's capable of putting a hit out on somebody. I've seen her write. It's not like something bad would happen, but I don't think she can make that happen. I guess my question is, take away the gang stuff, keep the phone GPS. Yeah. I know that it was something like there was something about the internet found the Cash App link, I think. Didn't they put a phone number into Cash App, and it was like his wife's picture and he was in it, and that's how they identified him or something like that? I don't know.
Just so you understand, because I read all the pleadings that you filed.
Oh, I mentioned this before, but a week ago today, I went to a happy hour with some old lawyer friends, and I came back and I was kind of drunk, and I did a 3-hour video. I didn't know it was 3 hours long. I thought it was 40 minutes of just criticizing Raven Liberty's motions in this new trial she has. It's also in Florida. This guy named Demetrius O'Neill. And I haven't rewatched it since then. I haven't published it. But I might. I don't know. We'll see. I need to watch some of it and see how bad it is. Gray said they found that thing quick. It was so funny. Then them being like, "You're creepy for looking up his wife's Cash App." Like, it's not our. It's not. It's not the internet's fault that Danny Polo is terrible at being undercover. You know, like it's kind of like the YSL detective that was undercover that they like put. They just had stand right directly in front of the camera. And then he didn't just like walk past the camera. He stopped like making sure you get like the profile and the front. He just looked right in front of the camera. There at least 2 times I accidentally doxed undercover people in the YSL case. I was just looking for like the video of their testimony and like their IG comes up. There was one detective, I typed in his name and it was his IG. And not only was it his IG, it was him next to his wife. And the picture was like them in front of their house. And it's like, I'm so proud of this house that I just bought where I live at with my family. As me, the undercover detective. This is where I live in Atlanta with my wife who looks like this. Like, what are you doing? How can you be that bad at being undercover? I wasn't even looking for it. And it was just the first result on Google. It was just your name and your face and where you live and what your family looks like. You can't be flexing your house on IG if you're an undercover detective. And I'm not even talking about what's her face, the mean one that doesn't know how to talk under her breath. Gaither. Gonna get me disbarred because I Google somebody's name trying to get their trial transcript up. Actually, no. I want to watch something funny. I watched Cats. I just Googled day 141. Day 141 YSL. I watched Cats' brutal critique of my writing yesterday for 3 hours.
Can do without.
And I just want to show. I want to show a little something. We're gonna watch Cat stream for a second. Get my get back right real quick. Not at all, actually. Okay, this is just one of my favorite moments. This is a complete, irrelevant to everything we're looking at right now. But it's my stream, so whatever. Oh, let me see. Here we go. Yeah, how you like it now, Kat?
The first caller never went outside. All she says is there's shots fired. On March 13th, when that witness goes outside, she sees that her car has been riddled by bullets. Now, there's additional evidence that Ms. Zachary would bring in that her daughter heard the gunshots the night before, but we're not bringing that in. So what we're trying to do is tie in the first call from March 12th and then the call from March 13th. There's more evidence, but we're trying to, as best, get in what is relevant to establish that there was a shooting. Again, all of these shootings are in response to what happens in February with Wyatt and Lucci getting stabbed.
Is it riddled with bullets?
Is it?
Excuse me, maybe I shouldn't say riddled with bullets, but there are bullet holes in her vehicle.
How many?
I believe there's one to her vehicle.
Okay. Y'all can no. Just no. We have got to figure out some things that we can do without.
I want to watch that again. Oh, I love that part. No.
Get in what is relevant to establish that there was a shooting. Again.
Hold on, I want to make sure I get to the right moment.
But do they need to know that somebody who had their car parked on the street or wherever it was parked, a stray bullet hit them.
It's right
It hit their car, not them, their car.
So, Your Honor, the first caller never went outside. All she says is there's shots fired. On March 13th, when that witness goes outside, she sees that her car has been riddled by bullets. Now, there's additional evidence that Ms. Zachary would bring in that her daughter heard the gunshots the night before, but we're not bringing that in. So what we're trying to do is tie in the first call from March 12th and then the call from March 13th. There's more evidence, but we're trying to, as best, get in what is relevant to establish that there was a shooting. Again, all of these shootings are in response to what happens in February with Wyatt and Lucci getting stabbed.
Is it riddled with bullets?
Okay, this is where you know you fucked up. It is this moment she knew she had fucked up. You got caught, okay? It's over. You're done. You gotta walk it back.
When you say, excuse me, maybe I shouldn't say riddled with bullets, but there are bullet holes in her
No. Bad.
vehicle.
How many?
I believe there's one to her vehicle.
Okay. Y'all
She
can.
asked, like, you think that Whitaker didn't already know when she asked how many, that you didn't know, that she didn't know exactly how many there were? How are you going to walk into that?
Y'all can know. Just no.
No? That's my favorite.
We have got to figure out some things.
Listen to that one more time.
No. Okay. Y'all can know. Just no. We have got.
I need to get a soundboard of that. No. Oh, man. I love it. Anyway, the reason I wanted to show that, Kat kind of snitched on me. Some of you may have. This is a complete coincidence. I didn't mean to do this. This is the conclusion of Mungtung's appellate brief. This is a total coincidence. I didn't know this happened, but it concludes, underlying these many enumerated errors is a single inescapable truth. The state's prosecution of Antonio Sledge has fallen far short of fundamental fairness. To the contrary, every phase of the state's prosecution of Antonio Sledge has been riddled with significant defects. The court should remedy those defects by granting the request for relief. That's a crazy coincidence. I didn't know that happened. I don't know who did that.
Got to figure out.
There are a couple other Easter eggs in there. Actually, I'm gonna plagiarize from Kat one more time, just because she has stuff organized on her channel. Here we go. I'll show one more. I'm particularly proud of this one for whoever did it.
Yeah, plotting is pointless.
Where are we? There we are. From Mr. Sledge's perspective, those are the most critical points of the plea negotiations. That count 30, in fact, charges 131, renders the concessions that he negotiated pointless. The point is pointless. Factual, I have a challenge. Next motion you write, use the phrase, I can do that. I don't know what it means. In California, they don't use a ton of Latin phrases anymore. I guess per se, maybe. Doesn't that mean it speaks for itself or something? Yeah, a dogmatic and unproven statement. I don't mind going left. I'm not going to say what it is, but there is something that Love did. I'm not going to talk about it because it's not my business. But there is a line of questioning that nobody except for Moontok and her knew what was going on. And it is so fucked up. It's his story to tell. I'm not going to tell it, but it is so much worse than anything that I've talked about. Like there's a history, and I hope that he wants to talk about it. If he doesn't understand, but it's so dirty. She's fundamentally a bad person. Speaking of bad people, let's go back to Detective Moretti.
All the rules apply the same, whether it's a civilian, whether it's a law enforcement officer, whether it's the state that subpoenas you, whether it's the defense that subpoenas anyone. If you get a subpoena, you gotta come to court and answer the subpoena, all right? If the lawyers want to ask you 100 questions and your answer to all 100 questions is, I don't know anything about that, you still gotta come and do it, all right? So the rules apply to everyone. The last thing in the world that I want to do is put witnesses in jail. I just want witnesses to appear. That's the defendant's constitutional right to put whatever evidence he wants in front of me or in front of a jury. It's also the state's right to put whatever evidence they want to put in front of me or in front of a jury. So, any questions for me about that? Okay. So, Mr. Gibson, do you want to call Ms. Lugo as a witness?
Yes, sure.
All right, so Ms. Lugo, you can have a seat in the witness stand right there. So once you're seated, I'll get you to scoot that chair forward as far as it'll.
Yeah, I just wish that I'd been more assertive with Moontok. Like, I knew, like, even before the revocation hearing, I knew, like, 90% of what the problem was. Obviously, there were more problems at the revocation hearing. But the first time I talked to Moontok was even before he was revoked. I guess people on, like, TikTok had sent him stuff that I'd written. Then he, like, followed me on Twitter and we started talking. I wish I'd been more forward with, like, hey, maybe I can help. But live and learn.
Okay. Adjust that microphone so it's pointed directly at your mouth. Raise your right hand for me. Swear to tell the truth, whole truth, nothing but the truth.
I swear to tell the truth and nothing but the truth.
Okay, you can put your hand now. Can you please state your full name and spell your full name?
Erica Lugo, Erica.
Yeah, I did do more than Derek Wright. In fairness, like from his perspective, he did get him a good deal. He got him, probation on a RICO, which is pretty good. They kind of stuck some stuff by him, but
Lugo, Lugo.
Mr. Gibson, do you may inquire?
Thank you, Judge. Good morning, ma'am.
Good morning.
Did you know Andre McFadden?
Yes.
Did you tell us
great
how
camera
before,
work, by the way.
Can you recall the first time you ever met him?
Back in like 2012.
Is this a different case?
You knew him before?
Yes.
You ever met this man here to my left?
Never.
You ever seen him before?
Never.
Have you ever rented a car that was to be used by him in New Jersey?
Never.
Did you make a police report that a vehicle that you had rented for Andre McFadden had stolen?
No. I plead the fifth.
What?
You have a problem?
You can't answer the question and then plead the fifth. Oh, you can't hear you when it's playing? Okay. She answered the question and then pled the fifth. It's a different case. Okay, I'm kind of enjoying it, though.
I never rented a vehicle for Andre McFadden. I rented a vehicle for myself.
Did I mishear, or I'm in a bit of a quandary?
No, hold on, man.
Yeah, Kat, we're definitely going to be watching this few minutes here.
You ask your question. The lawyer asks the question. The witness
This is
answers the
fantastic.
question.
Can you repeat?
Go ahead, sir. Ask.
No, you answered it already. What do you... Look at Fine. Look at this guy. He's laughing his ass off.
You ask your question. The lawyer asks the question. The witness answers the question.
Can you repeat?
Go ahead, sir. Ask.
Oh, man. What other case was streamed this? I know that I don't know. I know there was one other one that he did though. I don't know which one, but I know people recognize him from something. Oh, speaking of Florida, when's Courtney Clenny happening? Isn't that soon? You know, the OnlyFans model that accidentally stabbed somebody. It was basically the scene from like Kill Bill Volume 2 when like she throws the knife accidentally. Yeah, 12-1. Oh yeah, no, factual lie. Like another case. Man, there's a lot of interest in Courtney Clenny. That sentence would have meant something different a couple years ago. I gotta go to that rally thing. If it's still, I don't think the rally thing is still happening on Monday. But if it were, I would go. And not just because I want to meet Rihanna.
As well as the top of my page 3,
18.
State versus Cortland Henry, 19-1871 CF10A and 23-10643 CF10A. I continue to have Ms. Collins and Mr. Griffiths present for the state. Mr. Haddad, Mr. Nutt.
I'm going to tell you guys the story about my landlord. I've been involved in like a lawsuit with my landlord for like the past several months. So my building got sold, and the new landlords thought that I owed them like tens of thousands of dollars, and I obviously didn't. And they don't know that I'm a lawyer, and they tried to sue me. Well, they did sue me. And they kept lying to me, but they don't know that I know more than them. And the thing is, like, once you sue, you can only sue somebody once, and they're going to lose. So basically, I've just been living here for rent-free because they think that they can sue me and bully me into giving them tens of thousands of dollars. And I think they're finally starting to realize that I know more than them and that they're completely fucked. And it's just been really funny. And they keep asking for continuances. So I'm actually going to the Superior Court on the 16th. So I have no problem going back on the 18th. I think they actually may have tried to commit some fraud. It's pretty funny. I'll tell the whole story at some point. I think the lawyers are afraid to like tell their client that they're going to lose, and so they keep continuing it. It was really funny. They kept making like yeah, I could do a whole stream on this, but it's at first I was like concerned. I'm like, oh my God, I'm going to be homeless. And then I realized how stupid it was. And I've just been kind of amused by it for a while now. But yeah, I'm going to be at court on the 16th. So I can go on the 18th. Andrea Wolfson. Oh, cool. Oh, I saw there was a prosecutor. Matthew told me that there was what was it? One of the side quests in the Karen Reed case. There's a prosecutor disqualified. No, my court isn't being live streamed. I don't even think it'll like get to a hearing. I think they'll concede at some point. Oh man. All right. I don't know.
Present for Mr. Henry, who likewise is present. So I heard the evidence yesterday in the defense's pending motion to suppress statements of Cortland Henry. State, am I still correct? There's no other additional evidence, witnesses, or testimony you would like to present as to that motion? Correct. In defense, there is no additional evidence, witnesses, or testimony you would like to present.
Oh, and yeah, there's one other question. The thing about Dirk's case, I'm definitely going to go by there. I low-key tried to like slide into like Drew Feinling's DMs because I wanted to get on that case. But, you know, he didn't respond. It was basically like a stand situation. But, you know, maybe next time.
As to that motion.
We would like to present the testimony.
It wasn't his DMs, by the way.
The limited purpose of what happened.
Okay, no problem. Mike, can you hear him over there? Or do you want me to do it? Yeah, Mr. Henry, you can stay right there with the lawyers. Just speak loudly, okay? So we want you to hear the answers. Raise your right hand for me, please. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you put your hand down. Please state your full name and spell your full name.
My name is Bortlen, Cortlen, H-E-N-R-Y.
Okay. Sir, you may inquire.
Thank you, Judge. Mr. Henry, we just want to talk about what happened in the hospital on October 26, 2018. Do you recall running to the hospital? You got to speak up and answer yes or no. So what's to happen?
Yes.
Okay. And at some point, when you were brought to the hospital, were you placed into a room? When you were placed in that room, approximately how many officers were present?
5 or 6. You know, 5 or 6.
It's just so stupid. Well, he's asking him the question and he's answering the question. It's like, no, I know you're answering my question, but talk over that way in a completely different direction. Like, why don't you just do it? Why don't you do your job better? And then he can just answer the questions. How about that? So annoying.
And approximately, if you can remember, how long were you in the hospital prior to the 2 detectives arriving and speaking to you? So you were there for a little bit before they got there.
Oh, wait, what did you say?
The detectives.
The detectives when we talked to you?
And describe to me the room that you were in. Was it you were either by yourself or other people in the room?
It was like a private hospital room. Probably maybe like 4 different officers in the room. They had some outside of the room.
While you were in that hospital room, at any time were you placed in handcuffs?
Yes.
Do you recall who placed you in handcuffs?
One of the officers.
You're saying one of the officers. Are you differentiating officer versus detective?
Yes. One of the officers that were standing in the room.
Okay. And while you were in that room prior to giving your statement, was there always an officer in the room?
Yes.
And at any time were there any officers in the doorway?
Yes.
What were they doing?
They were just standing there.
You know, if there are officers in the room, there were definitely officers in the doorway at some point, because that's how doorways work. In rooms, really. See, like, to get into a room when there's a doorway, you have to go through the doorway. Unless you're the Kool-Aid Man. I guess if the Kool-Aid Man was a detective of the Miramar Police Department, maybe I'm wrong. But otherwise, if you're in the room, then you're in the doorway at one point.
At any time prior to giving your statement, did you feel as though you had the ability to get up and leave? What do you think, in your mind, what was your impression that would have happened to you had you tried to leave?
They wouldn't let me go.
Prior to you giving your statement to the officer, the detectives, at some point were the handcuffs taken off?
Yeah.
Why?
They wanted me to go to the they wanted me to go to
The urine center? Okay. Was there a bathroom inside the hospital room?
No, they walked me.
Okay, you said they walked you out, one of the officers?
One of the officers, one of the deputies that was standing guard in the room, they walked me out, they walked me into a separate bathroom, restroom outside.
Okay. And at that entire time while you were providing a urine sample, was there always an officer with you?
Yes.
And after you gave the urine sample, did you get brought back to the room? And then at some point, there are 2 detectives that come in, right?
Yes.
At any time during your interaction with those detectives, did they tell you to agree to leave? So then the first question.
Okay, cross-examination, go ahead.
Mr. Henry, you were taken into the hospital room for medical treatment, correct?
Yes.
You're aware that there is no urine sample in evidence, or collected in evidence.
As hard as you can, sir.
No, I'm not aware.
You say you were handcuffed. How long were you handcuffed for?
Most of the time I'm good. And the room was in the hospital.
So you were handcuffed for over 2 hours in that room, which you're testifying to.
Yes, until I'm good.
You say twice a day.
Until the police said I could leave. So I could leave.
Did you ever try to leave?
No.
Did you ever ask to leave? Did you ever discuss with the nurses that you wanted to leave? I'm going to show you what's being marked as states for evidence. Do you recognize this picture? Who's that a picture of? And where are you? Are you wearing handcuffs in this picture? This time I'm going to states B, the evidence in states 2.
Any
Couldn't you just said, hey, we wearing handcuffs?
objection?
That's so dramatic.
Without objection, States B for identification is now going to be in evidence. That's States Exhibit 2, only for the purposes of this hearing.
Mr. Henry, you agreed to ride with Detective Toyo after the crime scene? Where you said the crime occurred? Did you ride with Detective Toyota, who testified yesterday?
That was such a bad question. Did you agree to ride at the crime scene? No. No, he didn't.
Out where you said the crime scene occurred?
Yes.
And you were seated in the front seat with him?
Which I'm going to check, it's outside the scope.
Well, it is outside the scope, but over the defense's objection. Go ahead, sir. You can answer the question.
You did not ride with Detective Toyota?
I didn't ride in the front seat.
You were in the back seat. Okay. And at the end of your interviews with the detectives, they offered you a ride home, correct? They did not offer you a ride home? And they did not give you, law enforcement did not give you a ride home? No further questions.
Wasn't that already established by the
All right, based on that, any redirect?
Oh, wait, no, ready.
So just briefly on the photo.
Yeah, just go for it.
Mr. Henry, this photo that you were showing of you in the hospital, do you recall pictures being taken of you?
That moment.
Do you recall the officers taking photos of you? Was this taken before or after the handcuffs were taken off?
Objection, Your Honor, said he doesn't recall this speaking.
Hold on. Over the state's objection. Go ahead, sir. What's your answer to that question?
That was after
You said you recall some photos being taken of you. Those photos that you recall being taken, were they taken before or after the handcuffs were taken? After.
Colonel, how long ago was this? I think this was like 2019, 2018.
Based on that, any recross? Mr. Henry, I got a couple questions for you. You didn't get arrested that day, correct?
No, sir.
How'd you get home?
Family friends.
It was, yeah, October 26, 2018.
Someone came and picked you up at the hospital? And do you know what the time period was between that day and when you actually did get arrested?
That was October 26th.
I guess I could have just let it play for 3 more seconds.
I was arrested January 28th.
All right, State, based on my questions, do you have any additional questions?
No.
Defense, based on my questions, do you have any additional questions?
No, no.
Okay. Defense, any additional evidence, witnesses, or testimony regarding the motion to suppress?
No, sir.
Okay. So it's just argument. So, defense, it's your motion, so when you're ready, take your time. Your argument in support of your motion to suppress, and I assume you want to suppress both. I heard, which I think is contained on State's Exhibit 1, for this hearing, there's 2 statements. There's a longer statement that's about 40-something minutes, and then there's a very short one, which is like 2.5 minutes. You want to suppress everything? Okay, go ahead, sir.
He was not Mirandized, as we know. I think the state was stipulated for that. But what the issue is,
Another W for the caption.
is obviously, he was not at the police station to consider whether he was in a situation where he should have been Mirandized, whether the interrogation, as it were, constitutes an interrogation, whether or not it was custodial. Now, the defendant, the police had a shooting. We heard the testimony that a car arrived at the hospital with 2 bodies in it. Mr. Henry was driving the car. 2 bodies were taken into the hospital. Mr. Henry was taken to the hospital. And he told the nurse or somebody that was there that there was a drive-by shooting. He explained to him where it happened. We know from what the detectives testified, other police people, personnel, that were present and talked to Mr. Henry, then went out and walked the scene, canvassed the scene, looking for evidence of a drive-by shooting. They were unable to find evidence of the drive-by shooting, and the detectives came and talked to Mr. Henry. You've heard the tape, and I just want to quote from the transcript of it. The defendant is confronted with, as he said, and the police corroborated there were at least 5 or 6 cops in the room, everybody around him. He was in a situation where he's, I'm going to call it a custodial situation when we get to that point. But at any rate, the statement was, the defendant is confronted with Bortlen and Moretti. Hey, Henry. Hey, man, how you doing? What's up, man? How you guys doing? Hey, my name's Detective Bortlen, and this is Detective Mark Moretti. We're here to talk to you about what happened, okay? Listen, you need to be straight up with us and tell us what happened here. My understanding, you told these officers something, but the evidence doesn't show that happened right here. That's confronting the defendant with something that's implying Moretti said he committed a crime there. He was lying to the police. So we know that they're confronting him with evidence of falsehood. Should he have been Mirandized, because the rest of the statement is what they used to formulate the rest of the case. And I would submit to the court that the police had a duty to Mirandize him under that situation. They formulated, they have a crime, there's no question a crime committed, occurred. They called it a crime scene. The scene at the hospital was taped off. It was an active crime scene. Half the Miramar Police Department were there. 5 or 6 people were guarding him. He's in a situation where any person would feel they were not free to leave. He's in a hospital where people, he said there were 4 in the room with him. The detective corroborated there were a bunch of policemen with around him. Was there a duty to Mirandize him? I submit to the court that it's a situation. The defendant was, quoting from Hunter, Miranda warnings are required when an individual is undergoing custodial interrogation. As this court, this is the Supreme Court, as this court has explained, a person is in custody if a reasonable person placed in the same situation that his or her freedom of action was curtailed to a degree associated with the actual arrest. The proper inquiry is not the unarticulated plan of the police, but how a reasonable person in the suspect's position would have perceived the situation. Would a reasonable person in the situation of Mr. Henry have felt like he was not free to leave? Would he have felt like he was under arrest? The answer is obviously yes. He's there, a crime occurred. He's in a situation where the police are telling him they don't believe what he said happened. They made it clear that they think he's lying to the police. How would a reasonable person perceive the situation? You're in a hospital bed, you have policemen all around you, you're being accused of lying to the police. Would a person perceive the situation as one where they're free to leave? I submit to the court on the totality of circumstances, they would not. I concede the cases state that a hospital room is not necessarily the equivalent of a police station, but it's not the place where the inquiry occurred. It's how the inquiry occurred and what the situation is, how the suspect perceives. Any reasonable person, it's a reasonable man standard as to whether a person would reasonably believe they were in a situation.
I'm sorry. I apologize. Just pause 1 second. This is Mark.
Medical issue, I'm going to take the call. I apologize. Go ahead. I can go to Russ versus State, which is court, which they relied on it so heavily in its motion because it was a hospital situation. The court stated, quite correctly, police are not required to give Miranda every potential suspect. Miranda warnings only apply in custody investigations, court cases. Then it goes on to say the reasons for Miranda warnings at this stage because interrogation in certain custodial circumstances is inherently coercive. State may, under these circumstances, are inadmissible unless the suspect is specifically warned of Miranda rights until he decides to waive those rights. And then it says, for Miranda purposes, custodial question interrogation means question initiated by law enforcement officer after a person has been taken into custody or importantly is otherwise deprived of his freedom of action anyway. The determination of whether a person is in custody for purposes of Miranda is how a reasonable person in the suspect's situation would perceive his circumstances, relying on Yarborough in those cases. A person is in custody, quoting from Hunter, a person is in custody if a reasonable person in the same position would believe that his or her action, freedom of action, was curtailed to a degree associated with actual arrest. And I quoted that before. And that's the situation we have here. The defendant is in a room. He is confronted by the police that they don't believe what he's telling them. That he's lying to them and they have to come clean. And then he's not Mirandized. He's surrounded by a bunch of police. He goes to the bathroom. He has police taking him to the bathroom. He's in a room where the police agree he's surrounded by.
That was a good argument. I wish he'd spent more time on the bathroom thing. He went to the bathroom and they went with him. That indicates that he can't just walk away from them.
Police. They said there's a bunch of police, but 4 or 5 sound reasonable from what the defendant's saying. They're consistent with what already testified to. Is how many police are here. He's in a room. It's a confined place. He's got policemen around him, and he's confronted with evidence that he's lied to the police. Should he have been Mirandized? Absolutely. It's a statement that is going to be used against him in the obstruction case or accessory case. He should have been Mirandized. I think under the circumstances testified to as to how this occurred, the defense will pass the Miranda warning under all the cases given. Thank you.
Yes, Judge. Starting with Mr. Henry's testimony, he's clearly not being forthright with the court.
That's yeah, that's rich coming from him.
As Detective Cox, or Officer Cox testified to, when he first got to the scene, Mr. Henry was sitting outside on a stone bench when he went over and asked him what was going on. When he is questioned in the room by the detectives, they testified he was not handcuffed. In the photograph, he was not handcuffed.
Yeah.
Detective Toyota takes him on a ride. If he was really a security risk, if he was really somebody they thought was a suspect, Detective Toyota...
Okay, where's the not being forthright coming in? I haven't heard it yet.
Never would have taken him on that ride, and they never would have offered him a ride home. That offer for the ride home is at the end of that recording, where they say, like, we're going to make arrangements to take you home. He was not a suspect. As the officers...
He's so full of shit. We're going to make arrangements isn't the same as we're going to get you a ride home. It's after that would be the offer. So
the officers all testified they thought he was a victim. He was receiving medical treatment because, as the defendant stated, he was among the people being shot at. So when we look at whether something is custodial or not, it's the Ramirez test, as outlined in Ross, which is the manner in which the police summoned him for questioning. He was not summoned. He brought himself to the hospital. The hospital was a crime scene. There were officers there. Crime scene was there. They were processing the vehicle. They were processing the deceased. They were processing for evidence. Potentially
inside the hospital is absolutely not a crime scene.
Evidence physically located on Mr. Henry as a victim. The fact that the court heard the purpose, place, and manner of the questioning. This questioning was non-confrontational. He's not confronted with any evidence. They're not saying, we found bullet casings, not saying we found GSR. The confrontation is, we don't think this happened where you said it happened. And if you look at the transcript, if you read the transcript, you can see that. Because on page 9 of the transcript, they're like, look, here's a crude drawing. Did you guys get off the ramp here? Did you drive past the Chick-fil-A? They're trying to figure out where this happened. As I think two of the officers joked, we were trying to figure out if we even had jurisdiction over this case, depending upon where it actually occurred. There were not 5 or 6 officers in the room. That never happened. What the officers testified to is that there were officers around, nearby, and there were, because this was a crime scene. There was an active shooter loose based upon what Mr. Henry told police because he was a victim of a drive-by, which means somebody is driving around shooting up vehicles. So of course police are going to respond to that. But he's not confronted with any evidence of guilt, and even if he is, the court's considering that, as I cite to in, Pitts, which is very parallel to this case at the end of my first section for issue 1, is even if they are confronted with some evidence of criminal activity, that does not necessarily transform it into a custodial interrogation. He's not confronted with any evidence of him committing a crime. It's just, did this happen where you say it is? And when we look at the entire context of the conversation, the tone, the manner, this is not an aggressive confrontation of him being a suspect. This is, tell us what happened. Where's the location? Who were the victims? Did anybody have a beef with you? Are you posting on social media? They're trying to figure out what happened, what is going on, the basics of the investigation.
Are you posting on social media? That sounds like you suspect him.
And I believe all 3 witnesses testified, we believe he was a victim at the time of that. It's a reasonable person standard. The fact that he is having, documenting his injuries, that's normal in nearly any crime. A victim of domestic violence is going to have their injuries photographed. A victim of sexual battery is going to be transported to the Sexual Assault Treatment Center for potential examination. And they have the right to refuse, which is what the officers testified to. Had he wanted to refuse, we would have abided by that. There's no evidence, there's no evidence supporting that this was a custodial interrogation or ever transformed into a custodial interrogation. Miranda warnings were never required for this because, as the officers testified to, at the time that they were questioning him, they believed Mr. Henry to be a victim of this.
Doesn't matter what they believe. That's not the test.
Thanks, I'll give you the last word. Any guys want to?
But if I may, I have to disagree with the statements. I do think that the beginning portions of the transcript were replete with instances of the detectives confronting Mr. Henry with what they believe evidence of him lying and not telling the true story of what happened here. We see it in the second question. First question is Henry, but the second question is the evidence doesn't show that it happened there. You lied to us, you're not telling us the truth. If you go on to page 3, you see them confront him on the bottom. Here's the hard part. We're having a real hard time trying to understand is that we shut down the entire area. We had officers on the shoulder walking out. They didn't find as much as one shell casing. They go on, but they end with nothing to what you said adds up. You're lying, Mr. Henry. You're not telling us the truth. We think there's more to this. Later on, they go on, we should expect to find evidence here. And they're describing that to him. Right now, there's nothing, okay? I kind of think I know what happened because I got information that something else happened on the east side of the city. But you know, it sounds similar to your thing, but you need to tell us. You need to be straight up with us, okay? Next question. You're doing your friends a disservice. So repeated examples of them telling him at the beginning of the statement, what you said to us is untrue. You are lying to us. We've done an investigation. The evidence that we have doesn't match what you're saying. We're confronting you now with the lack of evidence to support your story. So clearly, they're confronting him with evidence of his guilt or involvement in some way in either the accessory after or the murder itself. And as far as arranging for a ride to go home and being in a ride along with the officers, that matters not as to what the environment was when Mr. Henry gave his statement in that hospital. He has testified to this court he's not guilty of free to leave. This court's going to evaluate that based on a reasonable person standard in his position. Whether or not he's in handcuffs when the statement occurs, again, matters not. There are officers. He was not free to leave the hospital room to go to the vet restroom. I think it's easy to understand that had he stood up and walked out of the hospital, they would have stopped him. He had been there for some time before the statement occurred. They were collecting evidence because there was a crime scene, including evidence, GSR from his hands, taking his clothes, things of that nature. Things that a reasonable person would not understand to be happening to a victim of a crime, but someone who may be a suspect of a crime. And at the very end, Judge, whether the officers have testified they believed him to be a suspect or not matters not, as the case law tells us. In Stansbury versus California, 511 U.S. 318, the police officer's subjective view of the individual is not bearing on whether or not the person believed they were in custody, whether they express it or not to you. It's what happened to Mr. Henry that day, and was he reasonable in believing he was not free to leave? Was his physical emotion or his right to decide what to do next curtailed by the action of the officers? And we would submit that it is, clearly, if you evaluate it just in the vacuum of that room prior to the statement. Thank you, Your Honor.
Listen, although normally the best practice would be for me to give you all a written order on there, I'm just going to go for the bench because of the time constraints that we're under here, and he set the trial. We're going to commence the jury selection next Wednesday. So, regarding the defendant's motion to suppress statements of Bortlen Henry, number one, I find witness Jordan Cox to be credible. I find witness Stephen Toyota to be credible. I find witness Mark Moretti to be credible. For the most part, I find witness Bortlen Henry to be credible, except maybe as to this handcuff issue. I just don't know. There's no evidence in front of me to the contrary. So let me put a couple things on the record right up front. Number one, it's clearly interrogation. Okay, there's no issue about that. They're asking him questions like, did you fire a gun that day? Did you have a gun that day? All right, those are questions that are meant to elicit or could elicit an incriminating response. It's clearly interrogation. That's not an issue. Number two, certainly the best practice would be for homicide detectives to just advise the person of his rights. And were they to advise him of his rights, then we don't have to go through this 2-day procedure, and I'm not called upon to make this determination. But for whatever reason, law enforcement doesn't really seem interested in doing that on a lot of these cases, so I have to make this determination. So really, the whole ball game here is whether he's in custody. And I'm familiar with the case law that the state cited. I've reviewed it again. I'm familiar with the case law the defense cited. I reviewed it again. The bottom line is, I don't think he is in custody. And I'll put the reasons why on the record. Let me also make this clear. If I had a photo in front of me, and I don't care where it was taken, if it was taken outside in the bay of the emergency room entrance, if it was taken inside the hospital, I mean, there's video cameras all over these hospitals, maybe not in the treatment rooms, but if I had any picture or any video of anything anywhere that at any point in time Mr. Henry had handcuffs on, I'd probably feel differently about this, but I don't. I have nothing that supports that in front of me, number one. Number two, they did in fact let him go. Number three, I think this defense is trying to give law enforcement too much credit. This is just a few hours after a double homicide occurs. And they're trying to, I guess, infer some nefarious purpose on behalf of law enforcement, that they knew Mr. Henry was a suspect, that they knew Mr. Henry was going to be charged. This is the perjury trap that the defense relies on or mentions in their motion. I don't think they had any idea what had happened up to this point. It was just a few hours after a double homicide. They're just trying to figure out what's going on, to the point of putting Mr. Henry in a
they did give him a GSR test.
Car and driving him to the scene that he says where this took place, because they're trying to figure it out. So they had no idea what was going on. They certainly didn't have any idea that Mr. Henry was going to end up being a defendant in this case. That seems to be corroborated by the fact that he doesn't even get arrested until more than 3 months after the fact. If he had ever asked to leave, I would feel differently about this. If he had ever told any witness anywhere that he didn't want to talk to them anymore, I would feel differently about this. He did no such thing. Again, based on the totality of the circumstances, I'm supposed to determine this. I listened to the questioning. I agree with the state in this part. It wasn't what I would call an intensive or aggressive questioning by the detectives based on their tone of voice and based on what they're trying to find out. They actually kind of go out of their way several times to say, wait.
Tone of voice? You were reading the transcript. How do you know the tone of voice? I thought it was a transcription. Was it audio? It must have been recorded audio.
We don't care if you had drugs. We don't care if you were committing another crime. We don't care about anything else. We're homicide detectives. We're trying to find out what went on in the homicide. As to the defense's argument that there is a large police presence at the hospital, I would suspect that if any person in this room drove up to the hospital right now with 2 dead bodies in their car, there would be a very large police presence that would respond almost immediately to that location. So that in and of itself doesn't really sway anything in my mind. I think any reasonable person would have to expect that you drive up to the entrance of an emergency room with 2 dead people in your car who were shot, that you're going to be confronted with a rather large law enforcement presence almost immediately. So again, based on the totality of the circumstances, where I do find that the best practice would have been to advise him of his Miranda rights, and where I do find that this was in fact interrogation, I do find, based on everything that I've put on the record, that Mr. Henry was not in custody. Therefore, respectfully, the defense motion to suppress both the statements is going to be denied. I'll enter a written order that reflects such. If and when we arrive at the part of the trial where the state tries to introduce this, that would be over the defense objection, which I would consider to be preserved, renewed, and contemporaneously made. So I'll enter a written order as to that. Next, state, you filed a state unopposed motion for relief from trial order dated July 8th, 2024, and that was for the purposes of filing a motion in limine to exclude the testimony of potential witnesses Michelle Boutros and Christine Bradley. I think you all told me yesterday the defense has no objection to your unopposed motion for relief from the trial order to file the motion, number one. And number two, the motion in limine is otherwise moved because they don't intend on calling Michelle Boutros or Christine Bradley as witnesses. State, is that correct?
I believe that's still correct.
Defense, is that correct? Okay.
The way it stands, I don't believe we would.
All right, so.
Should that happen, we can discuss it.
Okay, well, as far as the motion for relief just to file your motion, that's granted, and I'll enter a written order as to that. Regarding the state's motion in limine, I'll defer on that, and I'll enter a written order. And if no one calls them as witnesses, it's not an issue. And if someone's going to call them as a witness or wants to, I'll address it and give you a ruling on that. And if that requires me to send the jury out and even take a proffer from either one of these witnesses, it doesn't seem like it's going to be too long in time. But I'll take a proffer from them if I need to outside of the presence of the jury before I make a ruling. Although I can tell you, I have no policies, but as a general rule, credibility of witnesses is always at issue. So if we're talking about the credibility of a witness in the case, a witness that one side or the other side needs the jury to believe to have the jury believe their version of the facts of the case, then I would probably be hard-pressed to say that I would prevent any witness testimony in front of the jury in that regard. But I'll enter all three of those orders today. Ms. Wilcox, this one on top is granted, the reasons stated on the record, and then the motion limited underneath is deferred, the reasons stated on the record.
The motion hasn't actually been filed yet, since we just have to file.
Oh, you're going to file it. I'll consider
I'll
it.
file it today, but we won't.
Do they have a copy of it? They already have a copy of it?
Yes, they already have a copy.
All right, so I'll consider the state's motion in limine based on my ruling granting the relief from the trial order filed today, which is September the 5th, and I will defer ruling on it based on what I already put on the record. State, is there anything else that you need me to do for you regarding Mr. Henry today?
Not today, Your Honor. Thank you.
Defense, is there anything else that you need me to do regarding Mr. Henry today?
Not today. Thank you.
So Mr. Henry's going to keep a couple dates. Number one, next Tuesday, September the 9th at 1:30 p.m. We'll call that a trial status. So the record is clear on this. If there's going to be some sort of resolution, it has to be Tuesday afternoon. I can't take it Wednesday morning because I'm going to have the jurors here. There's simply too much human resources involved with this, and if Mr. Henry's case does resolve, and again to repeat what I said yesterday, it doesn't matter to me whether it does or it doesn't. I have a couple other murder trials that are in line with in-custody defendants, and I will use those jurors.
Not bring him here at 5 in the morning.
Yeah, just sign it. We'll give you a blank order. Just fill it out that says I need him here Tuesday, September the 9th at 1:30 p.m. 1:30 p.m. Mr. Henry, Tuesday would be the last day you're dressed like that. If we go forward with the trial on Wednesday, I need you in your trial clothes, okay? Dress for trial on Wednesday. We're going to have jurors here Wednesday. And then he has, besides the September 9th date at 1:30, he keeps his trial dates for September the 10th at 9 o'clock.
I don't need it order for 1:30, don't open it for lunchtime.
However you want to write it up.
Yeah, but it's 1:30, they usually bring on the afternoon bus.
Yeah,
When
let's
they
make
bring-
it.
Yeah.
We'll walk over it.
Yeah.
I'll take care of it. When?
Yeah, just,
Thank you. If we're gonna need it.
okay.
Thank you.
Okay, very good. I already sent you preliminary jury instructions. For the benefit, Mr. Haddad might be the only person I haven't done this with. Mr. Nascimento did it some years ago, but I bet he remembers. And Ms. Collins did it far more recently. But on Wednesday, the only thing I'm going to do is march in 5 panels of 50 at a time. I'm going to have the same trial schedule without the case information sitting in each chair. So they're going to be told that I need them from September the 10th through up to and potentially October the 10th, Friday, October the 10th. There's 2 court holidays in there, Tuesday, September the 23rd, and Thursday, October the 2nd. I'm going to talk to each of those jurors regarding their ability to serve only as to the statutory reasons that I can excuse them. Regarding the schedule only, the lawyers won't have to say anything on Wednesday, September the 10th. Once I get 60 people is the maximum that I can see in here for a jury panel. So if and when we arrive at 60 people that tell me that they can serve, they're going to be numbered 1 through 60. They're going to come back Thursday morning. When you all leave here Wednesday, you will have a copy of my questionnaire that they have filled out. It's going to be numbered 1 through 60 and a seating chart so you know where each of those jurors are going to sit. And then starting Thursday morning, we are only going to address those jurors by their numbers. I have lanyards numbered 1 through 60. District Court Deputy is going to pass them out every morning. He's going to collect them every afternoon when we're done with the jury selection process. So we're not going to refer to anyone's name on the record. State, you'll know the names because you'll have the list. Defense, you'll know the names because you'll have the list. And I know the names, but again, pursuant to the pre-trial orders that I've already entered, everyone's continued to be ordered. We're not going to disclose those names to anyone else. If any of the jurors' names are otherwise released to the public in any way, shape, or form, because I've already ordered the clerk not to do that as well, I am going to conduct an investigation and determine where the names are released from. And if I find out that someone has violated any of those pre-trial orders that I entered, I will conduct an indirect criminal contempt proceeding immediately. So I would highly hope that everyone will comply with those orders. We're only going to refer to the jurors by number starting Thursday morning. I think that's it. State, anything else you need me to address before we recess until Tuesday at 1:30?
No, Your Honor.
Defense, anything else that you need me to address until Tuesday at 1:30?
No, sir.
Okay, so I'm going to see Mr. Henry next Tuesday, September the 9th at 1:30 p.m. Division, Ms. Wilcox, that concludes Division FT for today? Yes. Division FT is going to be in recess until Tuesday, September the 9th at 8:45 a.m. I hope you all have a good rest of your morning. All right, Mr. Court report. That is it.
Okay. So, motion denied. Unsurprising. I didn't expect him to run on that. Yeah, that's quite a seemingly generous plea deal. I think, like Kat said, yeah, they don't want anything going to trial before Melly, especially considering how much came out of the first Melly's first trial with respect to Moretti and Michelle Boutros and Melly's mom and all that mess. Danny Polo being Danny Polo. I'm sure the state would like to get this resolved. 16 years is wild for a double homicide, but we will see. And actually, you know what? I'm going to save this. I'm going to save this for my Pat Labatt stream. I think I'm going to call it a day here. Gotta take the dog outside. But thanks everybody for watching. I'm not going to stream tomorrow. Maybe Sunday, but probably Monday. I have some work stuff that's kind of pending, so I'm not sure when that'll happen. Oh yeah, of course, Karna. If you do those shorts, let me know. I'll check them out, or like tweet about them or something. But yeah, that'll be it. Thanks for watching. Have a good weekend.